I can't go live. Oh wait, now it's being live streamed. Okay. Give me 1 second. Let me just confirm.
I'm going to start telling dad jokes if we don't go live here soon.
Just hold on for 1 second. I got a notice. It says that it couldn't go live, even though it says we are live. So I'm looking into it. Okay, we're good.
All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, January 26th. Today, we have 10 bills on the docket, and we'll start off with Senator Jackson, who has 2 bills. We'll start with Senate Bill 74. We'll go to 52, Senate Bill 8, 18, 54, 29, 161, 17, 41, and then we'll end up with Senator Carter's Senate Bill 30. So with that, Senator Jackson, welcome back to JPR. I know you love it here. We miss you. I'll kick it over to you to start off with Senate Bill 74. Welcome. The floor is yours.
I appreciate that warm welcome, Mr. Chairman. If you noticed over my shoulder, you'll see that beautiful medallion that I received while service and doing my service for JPR. I appreciate that. Mr. Chairman, Mr. Vice Chair, members of the committee, for the record, Senator Michael Jackson representing District 27 on behalf of Senate Bill 74. Senate Bill 74 is a very straightforward bill that simply provides enabling authority to raise the salaries of Maryland Circuit Court clerks. Presently, the maximum salary the clerks may receive, is $124,500. This legislation raises that amount to $146,500. The reasoning behind the legislation is the fact that the salaries of the circuit court clerks have fallen behind the salaries of other positions within the Maryland judiciary. Presently, the Maryland court administrators, judiciary, assistant administrators often earn more than the local elected clerks. Additionally, similar positions are compensated at higher rates in neighboring jurisdictions, including the District of Columbia and Virginia. Local clerks provide a myriad of services to Maryland residents, including issuing court documents for 200,000 new cases each year, recording 700,000 land records cases a year, issuing 50,000 business licenses per year, and processing over 30,000 marriage licenses each year. Local clerks also manage over 1/3 of all the positions in the Maryland judiciary, and their work generates approximately $400 million in fees to fund state, local, and county governments each year. Because the salaries of the clerks have fallen behind those in the local of their local counterparts and fellow officers of the court, the legislation simply brings their salaries better in line with those who hold similar positions. With that, Mr. Chair, I would ask you and the committee for a favorable report for this bill, and I have a few county clerks here to testify today in support of the bill. Thank you again.
Excellent. Thank you, Senator Jackson. We'll now move on to your panel, and we'll take questions at the end. So next up, I have the clerk of the court. So we have is Miss El-Amin here? Yeah, there you are. All right. I'm trying to unmute you. There you are. Welcome. How are you?
I'm doing well, Chairman. How are you doing?
Good. Good to see you.
Nice to see you as well. Once again, thank you very much, Chairman Smith and members of the committee for this opportunity to testify in support of SB 74. I would also like to thank Senator Jackson for sponsoring this bill. For the record, my name is Mahassan El-Amin, and I'm the clerk of the Circuit Court for Prince George's County. My testimony today is on behalf of the Maryland Circuit Court Clerks Association, which represents the 24 elected clerks of the circuit courts in Maryland. Our Clerks Association is seeking an increase in the salary cap for the elected clerks. As you probably are aware, and as Senator Jackson has testified that the legislature adjusts the maximum salary cap, but the actual salaries are set by the Board of Public Works. Today, we are asking for legislation to raise the salary cap for $124,500 to $146,500, so that the top salary that may be earned by the clerk is comparable with the salaries of other similar positions. Once again, the actual salary would be set by the Board of Public Works. Not all clerks receive the highest salary. The actual salary that is set by the Board of Public Works is based on the size of each jurisdictions, which are identified as large, medium, and small. Currently, there are 5 large jurisdictions, which consist of Baltimore City, Anne Arundel, Baltimore, Montgomery, and Prince George's County. The 6 medium large jurisdictions are Carroll, Charles, Frederick, Harford, Howard, and Washington counties. There are 6 medium jurisdictions, and those are Allegheny, Calvert, Cecil, St. Mary's, Wycomico, and Worcester counties. And finally, the 7 small jurisdictions are Caroline, Dorchester, Garrett, Kent, Queen Anne, Somerset, and Talbot counties. By law, the clerks cannot receive any cost of living raises or other interim pay adjustments. Our salary is only set every 4 years in accordance with the Maryland Constitution, which requires that our salary may not be changed during each term of office. The clerks request this increase in salary cap.
Please proceed. Yeah.
Thank you very much. It's supported by Chief Judge Getty and Pamela Harris, our state court administrator. It should be noted that this request is included in the judiciary's budget. My colleagues will discuss the comparable salaries for other similar positions and the services that the clerks perform for the citizens of Maryland. Our associations hope that you look favorably on SB 74, and thank you for this opportunity for us to comment and for the extra time. Thank you.
Excellent. Thank you very much. Thank you. And next we'll move on to Mr. Poyer. You are up. Good to see you again.
Thank you very much, Chairman Smith and members of the committee, for the opportunity to testify in support of SB 74. For the record, my name is Scott Poyer, Clerk of the Circuit Court for Anne Arundel County, and my testimony today is on behalf of the Maryland Circuit Court Clerks Association. As my colleague stated, we are requesting the legislature to raise the salary cap for the elected clerks of the Circuit Court to $146,500 so that the top salary that may be earned by a clerk is comparable with the salaries for other similar positions. Since the last time when the clerk's salary cap was increased in 2018, the salary for the clerks has fallen behind that of other judiciary employees of other officials in the region who perform similar duties. Since 2018, other Maryland judiciary employees have received a 16.5% increase in their salaries, along with cash bonuses that the elected clerks are not eligible to receive. Circuit court clerks now make less than court administrators who work in the same courthouses, who average approximately $144,000 in the large jurisdictions. Clerks make less than judiciary assistant administrators, averaging approximately $146,000. In fact, even though the elected clerks are considered some of the most senior positions in the judiciary, there are now over 30 judiciary job classifications with higher top salaries than the lowest paid clerks. Circuit court clerks also earn less than similar officials in our region. The District of Columbia's Superior Court Clerk of the Court has an annual salary of over $183,000. The salary for the clerks at the circuit courts in Virginia is over $150,000. The clerk of the United States Federal District Court in Maryland earns over $132,000, and Pennsylvania Proto notaries earn almost $137,000. The circuit court clerks are not asking for our salary cap to be at the highest level in the region at $183,000. We are asking for a cap which is approximately the midpoint of the salaries already being earned by officials in similar positions. My colleague will comment on the many services that the circuit court clerks provide for the citizens of Maryland, and our association hopes that you will look favorably on
Time.
And we'd like to thank Senator Jackson for sponsoring this bill. Thank you very much for the opportunity to comment.
Excellent. Thank you very much, Mr. Poyer. We'll now move on to the testimony from Ms. Dalton. Ms. Dalton.
Good afternoon. Thank you very much, Chairman Smith and the members of this committee. The opportunity to testify before you is Wonderful. It's probably the first time I've had the privilege of doing this. And I'm going to maybe go a little bit away from the script as you all have had it in front of you. Senator Jackson, you did a great job explaining what we do. A couple of the highlights, though, is that the circuit court clerks do things that other court clerks don't. We do the filings for criminal and civil cases, et cetera, and we do approximately the 200,000 new cases every year. But the additional things we do are the land record recordings, over 700,000 per year, 50,000 business licenses, 30,000 marriage licenses every year. And we also perform marriage ceremonies and administer the oath of office, excuse me, to our local elected officials and to our appointed judges. So as you can see, the circuit court clerks collect almost $400 million in fees that generate out to the state, county, and local governments. Our largest office has over 300 employees, and of the third of the positions that we are of the judiciary, that is approximately 1,477 employees. I'm proud to say that the circuit court clerks have kept their offices running throughout COVID, ensuring that all of our functions continue to be performed, even while other offices have shut down. We've become very creative. We have done things online. We go outside to swear people in for offices, whatever it takes to keep our office running. And we've recorded the deeds and the mortgages. We look for the opportunity with mailboxes outside our offices, et cetera, so that we are able to give those services. We're often behind the scenes, but we do serve an important role in people's lives. We are the face of the judiciary. When parties come into the courthouse, it's usually to the clerk's office they see first. So we run the offices, help businesses get their licenses, get married, sell and record deeds, mortgages, help with jury trials, large criminal cases. We are the appellate court for jury trials. And I want to thank each of you today for the opportunity, and I hope that we do get a favorable vote on the SB 74, and I'm happy to answer any questions. Thank you.
Excellent. Thank you very much, Ms. Dalton. And now I'll turn it over to the committee for questions. I'll just say this, the last September 16th, 2021, the Judicial Compensation Commission put forward a report, and I know this is circuit court clerks, but that report, I'll send it around to everyone on the committee just because I thought it captures the workload, the structure of the court system. It's something, it's a fantastic report that I think every member of our committee should become well acclimated to. So it's a very, very good report and a good primer on just how our judiciary functions and operates. So thank you all very much. Thank you, Senator Jackson. With that, seeing no questions, that'll conclude the hearing for Senate Bill 74. We'll now move on to Senate Bill 52. Senator Jackson, you're up.
Thank you, Mr. Chairman. Members of the committee, for the record, Senator Michael Jackson, District 27, on behalf of Senate Bill 52. Senate Bill 52 requires homeowners to maintain homeowners insurance after their mortgages are paid off. The bill will require owners of residential real property to maintain homeowners insurance with liability coverage of at least $100,000 for bodily or personal injury occurring on their property after the mortgages are paid off. This legislation comes as a result of a recent issue. As this committee heard at the end of session last year, we sort of ran out of time, Mr. Chairman, of a constituent, a neighbor of mine. A young lady was mauled by a dog in the yard of a homeowner, their neighbor, that did not carry homeowners insurance because their mortgage was paid off. Because of the incident, the young lady, Ms. Cassidy Tucker, whom the bill is named after, faces a myriad of surgeries and medical bills that are not covered because the homeowners did not carry homeowners insurance with liability coverage that typical homeowners with an active mortgage carry. In addition to dealing with the trauma of the situation, Cassidy now faces plastic surgery and other related costs that the responsible party is unable to pay. To attain recourse, the family of the young lady has been forced to do so through the legal system, as opposed to seeking it through an insurance carrier. A lien has been placed on the home of the homeowner, and now both parties are facing monetary hardships as simply that a simple insurance coverage could have covered. Requiring homeowners insurance to carry insurance with liability coverage, at least for mortgages that are paid off, will provide a needed level of protection for both homeowners and those who are victims of unfortunate incidents. Hopefully not as devastating as this particular incident, but incidents nonetheless. I appreciate the opportunity to bring forward this legislation at this date, and I look forward to continuing the discussion on this issue. Mr. Chair, again, we submitted this piece of legislation at the end of session last year. I thank you then, I thank you now, and we look forward to a favorable report. I'm look forward to answering any questions that I might have, but I also have a panel. So thank you, sir.
Excellent. Thank you, Senator Jackson. I actually, Sandy, maybe you can assist me here, but I don't have a panel witnesses signed up here at the moment. So Sandy, if you can help me out. I don't have a sheet here.
Do we have a Mr. Charles
I didn't have
Tucker?
it. No, he didn't sign up.
He did not sign up. Okay, I'll stand for questions.
All right, looking around the turnover to the committee for questions. Seeing none, you get off scot-free. This is how much love they've got for you.
I appreciate that. That
There you go.
medallion work. Thank you, sir.
All right, thank you,
We'll
Senator
speak soon.
Jackson.
Thank you.
Excellent, thanks. With that, that'll conclude the hearing for Senate Bill 52. We'll now move on to Senator, is Chair Kelly in the room? I thought I saw her enter the room a second ago.
She is here.
All right, Chair Kelly is up next with Senate Bill 8. There she is. Madam Chair, I'm asking to unmute you and you can turn on the camera when you're ready. Okay. Sandy, I'm going to move on to, is Senator Eckert here?
No, why don't you, do you want to move on to her witness, Paul Dnibber, and I can try to get her on after Mr. Dnibber?
DePaul Nibber, yes. Okay, from Mako, here you are. Mr. Nibber, we'll go with you. Floor is yours for Senate Bill 8.
Thank you, Mr. Chair and Mr. Vice Chair and members of the committee. My name is DePaul Nibber. I'm here on behalf
Hey,
of.
this is Sandy and JPR. She's in our.
Just a note here, a little PSA. Make sure to mute when you're not on. All right, thanks. Over to you.
Yeah, no worries. So I'm here on behalf of the Maryland Association of Counties in support of SB 8 with amendment. We strongly support this bill. We agree with its intentions of protecting our vulnerable minors across the state. And with that said, we would just urge an amendment that includes county involvement with the task force. And so our written testimony actually includes some amendment language to that effect. And that said, we urge a favorable with amendments report on SB 8.
Excellent. Thank you, Mr. Nibber. We will switch back over to the sponsor, Chair Kelly, if she's here. If not, that will end the panel and we can just move on to the next bill. We'll give her the opportunity to explain the bill if she comes back, but give her 1 second here and then we'll move on. Are there any questions for Mr. Nibber from the committee? All right, seeing none, thank you very much. Excellent. Hold on one. All right, so we're going to go ahead and move on to, that'll end the hearing for Senate Bill 8. We'll now move on to Senator Eckert. Is Senator Eckert here?
Senator Eckert is not here, but her staffer, Taylor Blades, is, and Taylor is going to present the bill on her behalf.
Okay. Taylor, you're up.
Great, thank you. So good afternoon.
18.
Thank you. Good afternoon, Chairman Smith and honorable members of the committee. Thank you for giving our office the opportunity to present Senate Bill 18, which is the Local Government Tort Claims Act for the Cambridge Waterfront Development. Sorry. So my name is Taylor Blades, and I'm the Chief of Staff for Senator Eckert. She sends her apologies that she could not be here herself, as this bill is very important for Dorchester County and Cambridge's future development, but she is currently in a voting session with budget and taxation. So she wasn't able to be here today herself. So Senate Bill 18, which passed in this committee last session, alters the Local Government Tort Claims Act to include the Cambridge waterfront development under local government. So this bill will provide the protections through the act similar to the ones afforded to other economic development entities across the state. So Cambridge Waterfront Development was established in 2018 by the Cambridge City Council and the Dorchester County Council. And since 2018, the waterfront development has fostered community partnerships and relationships across the county while planning for mixed-use redevelopment along the Cambridge waterfront. So as Dorchester County and Cambridge continue to grow and redevelop, Cambridge Waterfront Development, Inc. will continue to be an important partner in the meantime. Thank you for your consideration. And I believe we have two witnesses as well from Cambridge Waterfront Development here to speak today to you as well for some more information on what they do.
Excellent. Thank you very much, Taylor. And we have several questions from the committee for you. I'm kidding. All right, we'll move on to your proponents. So we'll start off with Mr. McLeod. What here?
You should show me.
All right, hold on. Let's go.
Yes. Yeah.
All right, there you go. You're up. If you could turn your camera on.
Yes, that's what I'm trying to do. There I am.
Excellent. There you are.
Mr. Chairman, members of the committee, thank you very much. My name is Chip McLeod. I serve as general counsel to Cambridge Waterfront Development, Inc. And with the Cambridge Waterfront Development, Inc. did submit some written testimony as well in support of Senate Bill 18. We appreciate Senator Eckert's introduction of this bill again. It was, as was mentioned by her office, this bill did pass the committee last year and during the session. And of course, last session was a little bit unique. Simply put, I think it's important mostly for the committee to understand Cambridge Waterfront Development, Inc. is a creature of the city of Cambridge and Dorchester County. Those two local governments several years ago entered into an MOU to create an independent nonprofit economic development entity to help them with the redevelopment of the waterfront. And anybody that's driven on Route 50 through Cambridge and they look to the right and they see where the hospital is and that nice piece of property to the right, when you come into Cambridge, that's the 30 or 35 acres that is being aggregated by Cambridge Waterfront Development, Inc. to hopefully redevelop that waterfront. It's important that the understanding is this is really as close to a local government entity as you can get, given the way it was formed. In fact, a large part of the property that CWDI will be dealing with used to be owned by the state of Maryland. And just today, the Board of Public Works approved the transfer of what we refer to as the port property into this economic development entity as part of this partnership to redevelopment the waterfront. So I'd be happy to answer any questions. I do know I saw there was some testimony with some folks concerned about the bill. And of course, the general concern is caps on coverage. Caps on liability and damages. We totally understand that, but we hope the committee will look at this, and CWDI is really an instrument of the local governments. And that's why we're really looking for this protection under the Local Government Tort Claims Act, because it's really doing the local government's work. Thank you.
Thank you very much, Mr. McLeod. We'll now move on to Mr. Powell. Is Jeff Powell here?
Yes, sir, I'm here. Can you
Excellent.
hear me?
The floor is yours. Yes, we can hear you. We can hear and see you. Thank you very much.
Thank you, Mr. Chairman. Appreciate the time. Chip pretty well covered it there. I'm the vice president of CWDI. And just for background, I was the past president of Dorchester County Council back 94 to 98, when we were lucky enough back then to have a partner with the state, the city, and the county pulled off the Hyatt deal here in Cambridge. So I now serve on this nonprofit. And I think one of the big things Chip alluded to there, the other third partner in this this group is the state of Maryland. Mike Friends from the Maryland Stadium Authority sits on our board as a governor's appointee, and Secretary Holt has been above and beyond helpful to us in moving this thing forward. So the state is already a big partner with us. The other thing from the legit side, they already cover most of this property. It's already owned by the city. I'm pretty sure it was already through covered with legit. There's a little bit on the county side. We're getting ready to try to pick up and negotiate with them on. That's also already being covered. The only piece it's not is the hospital property, but hopefully within the 5 to 6 year period, that's going to be demolished, sold off, and private and individuals will have the insurance on it. The only thing that'll be left will be a waterfront park. So the insurance should be very minimal from a cost perspective, but it'd be a big help to us to move this thing forward. So I thank you for your time. Appreciate the help and partnership with the state of Maryland. We would not be able to do it without it.
Excellent. Thank you very much, Mr. Powell. That concludes testimony for the proponents. We'll now switch over to the opponents, and we'll start off with Mr. Plaxton. Mr. Plaxton, you're up. Good to see you.
How are you, Mr. Chairman and members of the committee? Thank you for allowing us to be heard today. It's good to see you all. So I'm going to talk about, you all are aware that there's a $400,000 limit. I looked at the site plan, and there's 30 to 35 acres being developed that include docks, boat ramps, mixed-use housing, commercial use, entertainment venues, bars, restaurants, parks, paths, a promenade. And all of this would be extended immunity that is meant under the Local Government Tort Claim Act for government entities. From what I can tell from the fiscal note, this will save $10,000. And the proponent who just testified said, and I quote, "Insurance on this would be minimal, but passing this bill would be helpful." We are talking about a project that may cost billions of dollars. I don't know. I haven't seen what the cost is. And they've come to you to save them $10,000. Keep that in mind. You're trading constituent safety for $10,000. We saw a building collapse in Florida not that long ago where people died. They would be, if you put them under the Local Government Tort Claims Act and a stage were to collapse, or there would be some calamity somewhere on this 35 acres, your constituents would be limited to $400,000. And if it was a massive event where many, many people were injured, they would be limited combined to $800,000. So if you had dozens of people, you had the promenade fall into the bay, or you had a motor vehicle situation or any type of liability, you are extending that to save this corporation $10,000 in insurance, according to the fiscal note. They have insurance, and like every other nonprofit in the state can buy insurance to cover this loss. And that's why we're asking you on behalf of victims unknown to protect your constituents and not this corporation, which bars, restaurants, mixed-use housing was never meant to be extended to governmental immunity. That would be our testimony. Mr. McAllister is also on the call and can talk more about why this Cambridge development should not come under the Local Government Tort Claims Act. And thank you for our time.
Excellent. Thank you very much, Mr. Plaxton. We'll now move over to Mr. McAllister. Mr. McAllister, you're up.
Good afternoon, Mr. Chairman, Jim McAllister, members of the committee, and Senator Sidner, as a person who's recently relocated to Catonsville 21228. It's good to be great in 22128 with and have my senator here today. So let's talk about what this is all about. Damage caps are in the State Tort Claims Act. Well, what's a tort claim? And I know a lot of you are lawyers, so this may be a little bit more than you need to hear. But I think everybody who looks at this hearing and in the future is going to want to know that we understood what we were doing. And first of all, to have a Tort Claims Act, you need a victim. Who are the victims going to be if somebody gets injured at this development project? Probably somebody from Dorchester County or one of the neighboring counties. So you have a victim, but the victim doesn't just send a letter, "Oh, I got hurt, you get a check." No, the victim has to prove negligence. They have to prove that somebody that works for this private corporation was negligent. And what is negligence? It's carelessness. It's the failure to take a precaution to protect someone else's safety when you have a duty to do so. You can't just sit back and let something happen if you have a reason to believe there's a danger. You can't cut corners and shave a price tag here and there if it jeopardizes the public safety. And you can't turn a blind eye to a danger that, had you been exercising reasonable precautions, you should have seen. Now, the victim doesn't just automatically, once they prove negligence, get a check. Because if the victim is any way responsible for his or her injuries, it's called contributory negligence and they get nothing. So we're talking about fault-free people that can prove negligence. So who are the victims? Well, as long as the people that are injured are not injured to the tune of $400,000 or more, this bill is completely and totally irrelevant. So if someone gets hurt and they have a 5, 10, or even a $390,000 claim, this doesn't matter. What this damage cap does is it takes rights away from the most seriously injured, somebody who's injured to the tune of more than $400,000. Imagine an explosion at a marina and somebody's flown to shock trauma where they're in intensive care. How quickly do you chew through $400,000? And as Mr. Plaxton said, that 400, 800, what that means is if there's an individual incident, like something happens, something explodes, something burns down.
Mr. McAllister, your time's running short, so you could conclude.
Okay, I didn't realize there was a clock, sorry. So that means the maximum you get is 800. So, who are these future victims and how will we explain to them that we did this? And the other thing is, if the insurance companies are saying to the Cambridge Authority that you can save money by capping your liability at $400,000, what the private sector is saying is there's an exposure here, okay? And that it's a significant enough exposure that they're sending a price tag to them and saying that you need to buy this insurance because that's the risk.
Mr. McAllister.
So we would encourage an unfavorable report on this. If there's a solution for this, it's premium support. If these governments really want this private corporation to be indemnified, then help them with the premium costs. Thank you.
Thank you very much, Mr. McAllister. All right. With that, that'll conclude the testimony for Senate Bill 18. Thank you very much, Ms. Blades. Taylor, good job. And to the panelists, I'll turn it over to the committee for questions. Seeing none, that'll conclude the hearing for Senate Bill 18. Thank you very much, Taylor. Good to see you. All right, that'll conclude the testimony for Senate Bill 18. We'll now tack back to Senate Bill 8. I see Chair Kelly has joined us. So we'll have her testimony. I'm going to ask to unmute you, and you should be ready to go. All right. Oh, one more time. There you go.
Thank you. Well, you've had an interesting hearing and I've been a part of it while I was waiting. I just couldn't get in before. Thank you so very much. Senate Bill 8 is here because of grave concerns regarding the health, welfare, and education of untold numbers of Maryland children who are more vulnerable than usual, especially during the current pandemic. Many such children are in formal guardianships per subtitle 3 of the Family Law article. But a much larger number of Maryland's most vulnerable children are likely those in kinship care, a category of children for whom the Department of Human Resources has some oversight responsibilities, but had limited budget and or staff even before the pandemic. Before the pandemic, the department depended upon school personnel to report on children whose care and welfare appeared to be questionable. With much of the Maryland pre-K to 12 public education having been virtual rather than in person since the start of the pandemic, we have lost any systematic reporting on child welfare that normally we got from teachers, from guidance counselors, and by school social workers. At the same time, many vulnerable children have had to become caregivers for their younger siblings, including infants, as well as for elderly family members, while in many such cases, their communities have no broadband service and they're expected to do virtual education. In addition, if they are in low-income communities, their families couldn't afford the internet service anyway. So many haven't had schooling on any kind of a regular basis since the beginning of the pandemic. All of this is having a negative impact on their health and general welfare. Senate Bill 8 is here to help foster some systematic fact-finding on the welfare and on the mental and physical health of vulnerable kids whose physical, mental, emotional, and educational welfare cannot be monitored or addressed unless we know the extent of the problem. It is hoped that some of the federal funds received by Maryland to address impacts of the pandemic will be reserved to address the ongoing physical, mental, psychological, and educational needs of our most vulnerable children. Now, some of them have official guardians. Most of those we're talking about, and that's why this is in the family law article, aren't the ones who've inherited great assets from family members who've gone on to the beyond or anything. And the task force proposal, which is Senate Bill 8, is offered as a mechanism for clarifying the extent of the problem. There may be a few kids from that category, but certainly from those who the family law article would be more applicable to, and for determining the modalities and budget necessary to address the findings of the recommended task force. The task force representation is broad and includes many disciplines and perspectives. I know we are all aware of people in our communities and in our districts who fall into this category. Kids who are not in school, expected to learn virtually when they lack the wherewithal to do so. Kids whose parents were in many cases a part of the 1,100 people that testified in front of my committee about this time last year, that they hadn't gotten their unemployment claims paid and that the family didn't know how the family would be able to eat. The task force representation is broad. I'm asking that you include an amendment to add one more sponsor. Senator Michael Jackson wishes to be a co-sponsor. And in light of all of these considerations, I'm going to ask you to hold it a little while we work on some amendments, and I'd appreciate any suggestions that you have. But the problem is great. It's kind of a fuzzy area in that some kids with guardians are under estates and trusts, and others are in the family law article, and there are others that we don't know about yet because somebody needs to do a major assessment looking at what has happened to kids, lost from public education, lost from any community assessment, and lost from the normal resources that they need to grow up and to be healthy. I thank you so much for listening, and I ask for your strong support once we can do some amendments. And I'm certainly open to any amendments that this committee would recommend, and several of your members are co-sponsors on the bill. Thank you very much.
Excellent. Thank you very much, Madam Chair. We'll definitely take the amendments into consideration and we'll work on the bill. With that, I'll turn over to the committee for questions. Seeing none, that will really conclude the hearing for Senate Bill 8. Thank you very much, Madam Chair. We'll now move on. Excellent. Thank you. We'll now move on to Senator Riley with Senate Bill 54. Senator Riley, you're up. Thank you for your patience.
Okay, thank you, Mr. Chairman, members of the committee. Senate Bill 54 is probably something that you remember from last year. This has to do with authorizing procedures for obtaining marriage licenses and performing marriage ceremonies solely in Anne Arundel County. When this type of a bill came in last year, several other counties added on to it. And this year we're standing alone with Anne Arundel County. It'll be a local bill. This bill will be for our county delegation on Friday for a delegation vote, and would expect it to pass. Last year, we listened well to the testimony concerning the fear of abuse, of fraud, of underage people getting married. So I have asked the clerk of the court, Poyer, to share with us what has happened over the past several years when this virtual marriage license of application and ceremonies were done under the governor's executive order. Again, his story to me is no problems, well managed, no complaints, and I would ask for your consideration for this local bill. Thank you, Mr. Chairman.
Thank you very much, Senator. And now we'll move on to your panelist, Mr. Poyer. Good to see you again. Welcome back. Here we go, one more time. Here you go.
Thank you, bud. Thank you very much, Chairman Smith and members of the committee, for this opportunity to testify in support of SB 54. For the record, my name is Scott Poyer, and I'm the clerk of the Circuit Court for Anne Arundel County. My testimony is not on behalf of the Maryland Judiciary. I'm here representing myself as the elected official who is responsible for issuing marriage licenses and performing marriage ceremonies in Anne Arundel County. I support SB 54 because it offers marriage applicants more flexibility than the current system, which requires everything to be in person. As you may be aware, during the COVID state of emergency, Governor Hogan temporarily granted this authority in Executive Order number 2020-05-1302. My understanding is that SB 54 seeks to make this authority permanent. The temporary authority granted by the governor has since expired, but during the time it was in effect, my office conducted over 500 online marriage ceremonies and processed thousands of marriage applications. I would consider this real-world test a success. At the beginning of the state of emergency, it allowed some couples to get married who would otherwise not have been able to do so. And while it was in effect, it remained a popular option even after in-person ceremonies also became available. Some people may prefer the online option because you can give an unlimited number of guests who do not need to travel long distances to attend. And as Senator Riley mentioned, one issue that concerned me when we developed our process for conducting online weddings was whether it would increase the potential for child trafficking. However, we built checks into the process, such as requiring signed affidavits, photo ID, and dialogue with the applicants before the ceremony to ensure that both are eligible to marry and that neither appears to be coerced. My opinion is that the security of the online option is approximately equal to the in-person option. Because of the increased flexibility offered by online ceremonies and an approximately equivalent level of security compared to the existing in-person ceremonies, I support SB 54, and thank you very much for the opportunity to comment on this bill.
All right, excellent. Thank you very much, Mr. Poyer. With that, that'll conclude the testimony for Senate Bill 54. Turn to the committee for questions, and I knew there would be some. It's been a cold bench so far, but I knew it was going to heat up on this bill. All right, we'll go with Senator Castley and then Senator West. So Senator Castley, you're up.
Okay, thank you, Mr. Chairman. Just quick questions for you, sir. So there's two parts of this bill. One is to get the marriage license itself, just to apply for that. And then the second half is the actual marriage ceremony. First questions deal with the application for the marriage license. And that's just a matter of submitting an application with an affidavit under oath that complies with the normal requirements of identifying who you are, that you're not currently married, and that's all that is, correct?
That's correct, Senator Castle.
Okay, so then we move on, and there's actually a provision currently in the law that allows, it's kind of odd, because if you live in the county in Maryland, you have to come in and make the application, but if you don't live in the county, you can do it electronically. So we're already discriminating between people in and out of county currently in the law, right?
The current law would allow somebody to fill out an affidavit and send it in.
Right. If you don't live in the county, you can just do an affidavit and send it in. But if you live in the county, you have to come in, right?
We get most of those affidavits coming in from persons in the military who may be stationed overseas. So they send those in. We do take the affidavit if they are out of state.
Okay. So we're already doing those affidavits just for the license. And this bill is similar to those affidavits. Really, you're just letting everybody submit the affidavit if they want, correct?
That's essentially correct, Senator.
Okay, so that's not a big piece of that part of the bill. Let's go to the part of the bill that has to do with the marriage ceremony. Currently, I attended I did attend marriages during COVID where the minister or the person performing the ceremony was in the room with the couple getting married, and then they videoed the ceremony was done on video so that friends and relatives throughout the country could watch the wedding without traveling during COVID. And of course, that didn't require a law change because you can videotape anything, right?
Right, and we do allow couples to live stream the ceremony even from the courthouse. That's correct. Steve.
Right. So that's not a problem. So it's not a matter of keeping the issue of not overcrowding the ceremony. That can be easily handled under the current law by just letting people videotape or live stream. So the part of this that's really a little more challenging is that this allows the official performing the ceremony to also be somewhere else, whether that's a minister or a judge or anyone else. They can be somewhere else other than in the room with the couple getting married, right?
That's correct.
Okay. And why is it a problem for, I'm just trying to understand why that's a problem. Why do we need to change the current standard that says that these two people have to stand with a third person and under oath state their vows? What's the problem with that, with that we're encountering that we want to correct?
Well, in my mind, the current system is working as well. This just offers an additional level of flexibility. It's not meant to replace the current system. The current system, of course, is still working well. We do thousands of weddings a year. And some of them, exactly as you say, do get live streamed, webcast, so on and so forth. But this just gives a little extra level of flexibility.
Okay, but that extra level of flexibility, now the person performing the ceremony has to then sign off on the wedding, the marriage license, saying that these people did take their oath freely and voluntarily, and they witnessed that, and then file that, correct? That's correct. All right, but with them, and this is some issue we face when we deal with the long distance notary. You don't know who else is in the room with the couple stating their vows, do you? Actually, I often have the couple show me where they are. I'll have them take their phone and show me the location, because that's part of me checking to make sure that they're in. But that's not in the bill, because a lot of weddings are performed by a minister, or anybody can perform them as long as they're part of some kind of a church, right? And these days you can get ordained online. So yes, Senator. Sure. Okay, so we have a lot of different people performing these weddings. They're not required under this bill to ascertain what the situation is where the folks are taking their vows, are they? No, when I built in the protections, it's for the ceremonies that I perform. That you perform. All right, so we wouldn't know if this was the proverbial shotgun wedding. The person saying this was legitimate wouldn't even know it was the proverbial shotgun wedding, would they? And the reason that I say that's approximately equal to our current level of security is because that's the same if it's in person. We don't oversee the clergy, people who've been ordained. We just get a green piece of paper back that tells us that the wedding did indeed take place. So that's the same. That's the same whether it's in person or online. If a third party, we have to trust that the person actually attesting that they gave that the couple were married, lawfully married. We have to trust them, but at least now they're going to be the ones filing the attestation that this was a free and voluntary ceremony, but they weren't in the room with the person who they're saying freely and voluntarily entered the marriage relationship, are they? Both the protection is that both the couple and the officiant are attesting under oath. So if they were lying, it would be perjury. If they did, if either of them did lie, and that's the case now, whether it is online or whether that third party officiant is doing it in person. If they lie, it's perjury. But it's only one member of the couple has to file the affidavit, correct? That's correct. Yes, sir. Okay, so one member of the couple files the affidavit saying that we're going to get married and gives all the details. Then the minister, the officiator, they then file the affidavit saying that they're lawfully married, right? That's correct. Okay. Under the current law, now under the proposed law, the form that's going to be signed by the couple, both of them sign the form. Both of them are attesting on the form, and that's the same. So they'll have to mail this thing around, or what?
If, so switching between the two, if they're coming in person under the current law, only one of the couple needs to come in and swear that the information for both of them is correct. They're swearing under oath. If they're sending in one of the affidavits, then both of them are signing and both of them are swearing that their information is correct.
But the affidavit signed out of your presence.
That's correct.
Right. So they sign an affidavit saying, I'm going to marry this person freely and voluntarily. Now the neutral person being the officiator, they're going to sign and say, I gave them the oath, but they don't know whether there was any undue coercion involved in the wedding, though, do they?
We don't have any oversight over the third parties, in person or online.
Right. They don't have an opportunity to gauge whether or not they were intoxicated or anything that you would normally, in-person ceremony would allow that person to do they?
I check for all those things.
I know, but you're not involved in these new ones.
Oh, I'm sorry, Senator.
You're not involved in most of these new ones. On the video stuff, that's involves people who are not you.
Yeah, the third party. If a third party does it, we are not involved.
Okay. All right. Thank you. Appreciate it.
Thank you very much, Senator.
Excellent. Thank you very much, Senator Castleman. I'll switch over to Senator West.
Thank you, Mr. Chair. Actually, my question is for Senator Riley. In your introduction, you indicated that last year there were some amendments to the bill to add other counties.
Yes.
What's happened this year? Did the other counties decide not to be involved, or?
Well, Senator, one of the tenets that we operate in generally in the Senate is local courtesy. I'd like this bill to stand alone based on my request and Clerk of the Court Poyer's testimony. I believe you may get some other bills from other counties, but I think it may have muddied the water last year. So I'm encouraging every county to consider it. I think there were 4 or 5 additional counties added to the bill last year, but then it did away with that local courtesy, which I'm counting on to get this bill through this year.
I guess my concern, and it's not a big concern, is that we're going to get a flood of counties. That once this bill gets passed, if the bill
and Senator West, it should be an easy decision once they come in.
Yeah. Okay. Thank you, Senator.
You're welcome.
Excellent. Thank you, Senator Riley and Mr. Poyer. 2022, you can meet someone online and you can marry them online. All right. All right. With that, that'll end the hearing for Senate Bill 54. Thank you very much. Now, next we have Senator Elfreth is here, and we have Senate Bill 29. Senator Elfreth, welcome. Unmute you here. The floor is yours.
Thank you so much, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Senator Sarah Elfreth representing District 30. Here back, it's my 3rd time around for this bill, but this bill has been here for 7 sessions in a row. So I want to be respectful of the committee's time, Mr. Chair, and not, and I'll try to be brief. I want to just highlight the need for this bill. Ending child marriage is not only relevant, it is timely. It's not a small problem. Thousands of minors have been married in Maryland over the last 2 decades. 85% of those minors have been women. In 2019 alone, 64 children were married. Of those 64, 10 children were married to someone between the ages of 25 and 29. 3 of those children were married to a person aged 30 to 34. We're talking about 16 and 17-year-olds. The public health data is clear on this, the negative impacts of entering this government contract before you are 18. Child marriage can lead to significantly harmful outcomes. The vast majority of girls who marry before 18 face significant and lifelong challenges. Marrying before 18 doubles the chance of living in poverty. Those who marry before 18 are 50% more likely to drop out of high school. Marrying before 18 triples the likelihood of domestic violence. And those who marry before 18 have a 70 to 80% greater chance of getting divorced. Other states have recognized the importance of protecting children, including our neighboring states of Pennsylvania, Delaware, Virginia, and New Jersey. The bill is, and I'd like to, Mr. Chair, thank this committee for over the years working with me to find a balance for this bill. It accomplishes 4 major things. It raises the age of marriage from its current 15 and a half under certain circumstances, 15 and a half. It raises that age to 17 with no exceptions. It provides for no more than a 4-year age difference between the potential spouses. It creates a judicial review process to ensure that the court can independently determine that the relationship is in fact voluntary and free from coercion, as well as that the 17-year-old seeking to marry is mature and capable of self-sufficiency should they need to be. It ensures that a 17-year-old who successfully petitions for a marriage license is also emancipated. And this is important, committee, because we added this emancipation language 2 years ago to ensure that 17-year-olds who are found by the court able to marry will be able to, should they need to get out of that marriage, sign a contract for a cell phone, open their own bank account, sign a lease, retain an attorney, and critically petition for their own divorce. Under our current law, where you can get married at 15 and a half under certain circumstances, you are not able to petition for your own divorce until you are 18. So this emancipation language is important. It ensures that vulnerable women and men are empowered with their ability to get themselves out of a potentially abusive marriage. Today, you will hear from a number of witnesses. I'm so grateful that Sasha Taylor is back with us to share her very personal story, and I want to thank Sasha for taking the time to do that. I would like to call your attention, the committee's attention, to 2 pieces of written testimony in your packet, folks who were not able to be here. The Catholic Church has been a proponent of this bill for a number of years. Committee members will recall Father Witt's powerful testimony 2 years ago. The written testimony is in your packet, as well as the American Academy of Pediatrics to give us a very full public health perspective on this challenge. Senate Bill 29 ensures that if a minor is marrying, they're making that decision for themselves rather than being coerced and are able to escape an abusive home should they need to. It ensures that the union of a pregnant 15-year-old and a 37-year-old, a union that occurred in 2018 here in Maryland, is not heretofore will not be sanctioned by a marriage and a government contract. Senate Bill 29 truly represents the best balance to end child marriage here in Maryland and get us out of the dark ages. And with that, Mr. Chair, happy to answer any questions or allow the panel to move forward. I ask for a favorable committee report. Thank you.
Excellent. Thank you, Senator. And we'll move on to the panel and we'll take questions at the end. And so next we'll have Ms. Swegman, you're up. And then we'll move on to Ms. Taylor. Welcome.
Thank you, Chair Smith and Vice Chair Walstricker and honorable members of this committee. My name is Casey Swegman. I'm with the Tahirih Justice Center, and it's probably no surprise to folks that I'm here testifying in support of SB 29. Tahirih is a national organization with an office in Baltimore. We serve survivors of forced and child marriage, domestic violence, and human trafficking. We've worked on hundreds of forced marriage cases, including many right here in Maryland. As Senator Elfreth already shared, the research is clear that child marriage can lead to devastating lifelong harm, including greater vulnerability to domestic and sexual violence, increased dropout rates, increased risk of future poverty, and up to 80% divorce rates. In the overwhelming number of cases, it is an underage girl being married to an adult and entering a legal contract on unequal legal footing. This is a strong bill that is the result of 7 years of thoughtful dialogue and bipartisan compromise, and it is informed by many of you on this committee. It is time to put an end to our reputation as a regional destination for child marriage. As of this year, Maryland has weaker laws than most of our neighbors, and in all, 27 states, red, blue, and purple, have enacted reforms since 2016, including 12 that have conditioned eligibility to marry on emancipation, either naturally at age 18 or after petitioning a court. And this bill makes a limited exception to age 18 for court-emancipated 17-year-olds, and crossing that threshold into legal adulthood prior to marriage makes a critical difference to one's ability to protect themselves from abuse. And this bill incorporates many best practices, including the appointment of counsel, background checks, a residency requirement, a waiting period of 15 days between emancipation and marriage, and eliminating the harmful parental consent exception, which often conceals parental coercion, and the pregnancy exception, which often ignores evidence of statutory rape. Tahirih knows that setting the minimum age of marriage at 18 without exceptions is the strongest way to protect children from the harms of child marriage. But we are not here to let the perfect be the enemy of the good. This bill will go a long way to protecting children from being forced into marriages where they are then trapped on an uneven legal playing field with limited ability to get help. And I thank Senator Elfreth for its introduction and Chair Smith for bringing it up for a hearing today. And I respectfully ask for a favorable report without amendments. And I thank everyone for your time.
Thank you very much, Ms. Swegman. And now we'll switch over to Ms. Taylor. Welcome. There you go.
Good afternoon. My name is Sasha K. Taylor. I'm a third-generation victim survivor of a forced child marriage, living now in the Washington, D.C. area. Though this took place in Arizona, this could have taken place anywhere in Maryland or any other state that currently allows child marriage to take place. I was a sophomore in high school in 1991. I was told to go to my grandmother's home for dinner. That night, I discovered I was to be engaged to a man 7 years older than me, whom I had never met or spoken to before. I was surrounded by family members, forced into submission, and forcefully engaged that night. A few months later, this individual's student visa was expiring, and the families agreed to marry us legally in a local court. I have one photo from that day. I'm sitting in a waiting room surrounded by family. Still to this day, I don't know who filled out my paperwork. Everyone is waiting for us to be called in front of the judge. I just walked up and repeated what I was told to say. I was not able to speak up. No child is able to speak up for themselves when these atrocities are occurring to them. No child is able to speak up when they're surrounded by family, pressured or abused into submission, and nobody advocates for them. No child is able to speak because they have not discovered the power of their own voice and don't have the privilege of choice. No child is able to speak because nobody ever questions anything since it's the law, and local government employees are simply checking boxes and doing their jobs. Abuse and socioeconomic background are the two common factors among child marriage survivors. My father was physically and emotionally abusive, and to get me out of that abusive household, my mother and grandmother arranged for this forced marriage, but they too were coerced. They didn't imagine any other choice for me because they didn't have one either. They didn't have the privilege of choosing college or a fulfilling career. It was a cycle that kept repeating over and over again. I did not experience high school like a kid should. Instead, I was groomed to go in a back room to make out with someone I was not the least bit attracted to, be a daughter-in-law, think of the kids I was supposed to have, and be with him and stay home and be a wife. I was not allowed to leave the house to go see my family. I still cannot believe I'm writing a victim impact statement about laws that should not even exist in today's day and age. These laws only benefit those that seek to exploit their children and repeat cycles of abuse. These are archaic laws made in early times when women were seen as property and married off to some still as children to secure land deals when the US was still a young territory. These laws need to change. And as a first world country, America needs to do better to protect its minor children and their human rights.
Thank you very much, Ms. Taylor, for your testimony. Next, we'll move on to Mr. Poyer. Welcome.
Thank you very much, Chairman Smith and members of the committee, for this opportunity to testify in support of SB 29. As I've said before, for the record, my name is Scott Poyer, Clerk of the Circuit Court for Anne Arundel County, and my testimony today is not on behalf of the Maryland Judiciary. I am here representing myself as the elected official who is responsible for issuing marriage licenses and performing marriage ceremonies in Anne Arundel County. I am in favor of SB 29 because I do not feel the current laws provide enough protection for minors who may find themselves being pressured into marriage. I believe there's a lack of safeguards for minors under the current system. Under the current law, as Senator Castley has mentioned before, only one applicant needs to appear to make the marriage application and swear that the information for both parties is correct. And the marriage ceremony itself can be performed by virtually anyone. Anyone can be ordained to perform weddings in Maryland. It takes about 5 minutes and costs $29.99 to fill out the online form to be ordained. The bottom line is that we may never see the minor being married, and all we have is a green piece of paper that gets returned to us, notifying us that the marriage took place. The applicant gets a valid Maryland marriage license recognized in all 50 states. If such a wedding took place fraudulently or under duress, it is especially bad for the minor because they would not be able to challenge the marriage until they turned 18. I think it is worth building in some extra safeguards into the system to help prevent minors from marrying against their will. And I support the proposed legislation because it provides better safeguards. By raising the minimum age to 17, requiring an attorney to be appointed to represent the minor, and also requiring a court hearing for each case. And thank you very much for the opportunity to comment on this bill.
Thank you very much, Mr. Poyer. We'll now move on to Mr. Cuneo. Help me out on that one. Sorry about that.
Thank you. Thank you, Chairman Smith and members of the committee for the opportunity to testify in support of SB 29. For the record, my name is Charles Cuneo, and I'm a physician and assistant professor of pediatrics at Johns Hopkins University. I'm here today as a concerned pediatrician and officially on behalf of the Maryland chapter of the American Academy of Pediatrics. The MDAAP is a statewide association representing more than 1,100 pediatricians and allied healthcare practitioners, and is a strong and established advocate for promoting the health and safety of all the children we serve. The MDAAP is in support of SB 29 because it provides critical protections to help close loopholes in current state law, which will continue to leave children vulnerable to exploitation and abuse under the guise of child marriage. Furthermore, we know that child marriage itself can be harmful. In a 2011 nationwide study premiered in the journal Pediatrics, women who married before the age of 18 were found to be 43% more likely to suffer from depression, 89% more likely to be dependent on drugs, and 95% more likely to be diagnosed with a psychotic disorder over their lifetime. As pediatricians, my colleagues and I see firsthand the devastating consequences of child marriage. It is one thing to read the statistics on the many adverse health outcomes for individuals affected by child marriage. It's quite another to disclose a new HIV diagnosis to a girl married to a man twice her age, to treat the depression of a child struggling with the consequences of forced marriage, or to have to ask for consent to provide medical treatment to a teen from her decades older husband. Passing SB 29 would represent a major step forward in protecting the health and safety of children in Maryland, one which is long overdue. A favorable report is requested. Thank you for your time.
Excellent. Thank you very much. And that'll conclude the testimony for the proponents of the bill. So thank you to the panel, especially Ms. Taylor. We'll now move over to the opposition panel. Mr. McAvoy, oh, there we go. You are fully framed in the screen. There you go. Good to see you, Mr. McAvoy. All right. The floor is
You can hear me now?
We can, yes.
Good to see you, Senator. Nice seeing you a couple months ago downtown.
Yeah.
On this bill, I see a lot of changes. It has been a process. I do see some things that are more admirable than previous years. As I look at this, though, I'm still looking at instances where we would not want to deny this. If two youth want to get married, the instances that keep coming up disturb me. In other words, we keep hearing about someone coming to the clerk and one's twice the age of the other, and it's always a man twice the age of a girl. And the clerk isn't saying something. So I'm looking at this sheet and it's got all these stipulations and things that are going to be checked. And I guess I'm just wondering, this cannot be the most efficient process. It seems to me, and I couldn't tell you what it is to do the clerk's work. I've only been through, seen a friend one time go that route, but it just cannot be the most efficient way for this form to be looked at. All these things checked off, and then the clerk not say, you know what, we would want to defer this because of X, Y, and Z. When you're getting into human trafficking, this and that, the other issue I could think of off the top of my head is we have an onus that we're placing on people that are coming to the clerk to get married versus others who are not. I don't know if we have an equity issue there, but it just, I do like to see that we're seeing some movement on the flexibility with this. For instance, say a 16 and a 20-year-old or a 17 and 20-year-old for adults versus just this thing where we have 42-year-olds coming in with 16s. Why are we not flagging that off at the top? And I think that we recoil inside, but we're not at the clerk's office. Why aren't they recoiling? Why aren't they saying something's a little off here? I thank you for your time.
Excellent. Thank you very much, Mr. McAvoy. That concludes the testimony for Senate Bill 29. We'll now move to the committee for questions, and I see that Senator Huff has a question. So Senator Huff, and then we'll move on to Senator West. Senator Huff.
Yeah, just a really quick question.
how does this bill as it came into the Senate compare to what we passed last year out of committee?
Senator, thank you for your question. This committee did not take a position on this bill in 2021, or I believe in 2020. The last time it came out of committee and onto the floor was in 2019, but not in the last 2 years.
Okay, all right.
Senator, this is in the same posture as it passed out of the House, though, third reader House last year, I think.
Yes.
Okay, and so, like, all right, I thought we did, I guess we didn't move forward because I thought that we'd always been negotiating. We've, with apologies, because it's been in front of us 7 years. I think some years we've passed it and some years we have not.
I understand.
And then, all right, so when we passed it out in 2019, what was the age that we, and if you don't remember, because I don't remember, but what was the age that we put it at in 2019?
It was not my bill then, but I believe it was lowered to 16 and did not
Okay.
have any of the protections that we've added on in this bill. For instance, the appointment of an attorney, the ensuring through a judge that, to the best we can, that there is no coercion or trafficking incidents. The age cap of 4 years is an addition to the bill that was not there in 2019, as well as the emancipation for those 17-year-olds should the judge grant the petition to marry.
Okay, so under yours, at 17, they can with a judge emancipation. All right, thank you.
Thank you.
So, thank you, Senator Huff. We'll now move on to Senator West.
Thank you, Mr. Chair. I remember this bill from years past, and the sticky wicket for me has always been the following hypothetical. To put it in the context of this year's bill, a 17-year-old junior in high school and her 18-year-old boyfriend get involved sexually and she gets pregnant. According to this bill, there could not be a wedding because she hasn't turned 18 yet. So she would have to deliver her child in wedlock. And I want to ask Mr. Cuneo, Dr. Cuneo, I guess, Dr. Cuneo, because you spoke for the pediatricians. And there is a paragraph in the testimony that the lobbyists submitted on your behalf that adverts to the fact that parents may believe early marriage is in their daughter's best interest, especially if she's pregnant. Then you go on to talk about various statistics about how when girls under 18 get married, there's a high percentage of bad things happening. But wouldn't you agree that in some cases, good things happen? If the girl gets pregnant and gets married to the boy who she loves before her 18th birthday, so that she can deliver her child not out of wedlock, but as a married woman, aren't there sometimes good things that happen from that situation as opposed to forcing them to hold off?
Before I unmute Mr. Cuneo, Senator, do you want to address the hypo?
I do. Thank you so much, Mr. Chair. And thank you, Senator West. In this bill, 17-year-olds could get married while we go through the process that the bill delineates. It does say, however, that the judge cannot make the assumption that if the couple is with child, that is sufficient enough reason to grant the marriage.
Okay, that helps. Thank you.
All right, Mr.
Dr. Cuneo, do you want to talk about the more medical aspect of that, which is that I'm assuming that in many cases, bad things happen to girls who marry before 18, but in many other cases, they go and live very happy lives.
I think the problem is that when we look at, the data that does not really flesh out, we see more of the former than the latter. And because of the unique, vulnerability of minors and the loopholes we've already described, it seems, this is a situation where we are allowing really terrible things to happen, and I don't think that the risk outweighs the. I think the benefits do not outweigh the risk in this situation. Obviously, there are always hypothetical examples and anecdotes that can be used, but looking at the data collectively and the worst possible scenarios, I think that this is just a clear choice.
Okay. Thank you very much.
Thank you, Senator West. We'll now move on to Senator Castley as a question.
I'm still muted. No, you can hear me all right now? Thank you. So it's interesting, we have the juxtaposition of this bill, which says, be cautious on marriage, that bad things can happen, people can be forced into marriages that are not appropriate. Then the last bill, which says, hey, it's only a marriage, issue the marriage certificate online, do the ceremony online. The officiating official doesn't need to be there in the room to see what's happening. You can pretty much, make this a very simple matter. So with those two out there, I guess my question is really for Casey Swegman. I think you were the one that was most forceful on this. Is it the forced marriages that you talked about? Is this a problem that's only for minors? Do we see forced marriages of people over 17, or is this typically only 14, 15, 16-year-olds? If you can unmute Ms. Swegman, please.
1 second here. There you go.
Thank you. And thank you, Senator Castley, for the question. I think in this instance, just to respond to the question of how does this bill relate to the bill that we previously talked about, the Tahrir Justice Center doesn't have a stance on that, but this bill would make sure that any minors who were seeking to marry, whether they're seeking a remote marriage or not, would have to go through this process of emancipation first, and therefore they would be brought before a judge and get that appointed counsel. So there is a safeguard whether or not you do allow that bill to go forward. There would still be a safeguard for minors. And I think
I got it, but you seem like you were advocating on behalf of women, I assume mostly women who are entering into forced marriages. And I'm just trying to understand, based upon your experience, is forced marriage simply a prerogative of 15, 16-year-olds, or does it go to 18, 19-year-olds?
Yeah, that's a great question. And it is not just the prerogative of minors. What we see as the critical difference here is that once you reach the age of 18 in Maryland, you're able to walk out the front door with the right to go to a domestic violence shelter, the right to contract with an attorney for a protection order if you want one. You have all the rights and access to the systems of protection that you do not have as a child. And that's why this bill creates that pathway to marriage for 17-year-olds through emancipation first, because it is relieving anyone who is party to a marriage of any legal disability that would restrict them from getting the help they need and the supports and services they need. That is the sort of crucial part of this bill. So no, 18 does not mean that forced marriages stop happening. It just means that you are incredibly more empowered to get yourself the help you need to prevent that forced marriage.
It's just, having done many domestic violence cases over my legal career, I know that while women may be legally empowered to do things, it's often, in my experience, the case that based upon past trauma or what have you, that much as they have a legal right, they don't assert that right. They either hesitate, fail, whatever you want to say, to assert that right because of their past experiences, and maybe they would be vulnerable to forced marriages.
You're absolutely right. There are always challenges, whether you're 17 or 71, if you're a woman who's experienced trauma or domestic violence. This bill is addressing one particular piece of vulnerability, but it doesn't solve all the problems, but it really addresses a huge one. So I thank you for your comments, actually, and I appreciate the question.
Thank you. Thank you, Mr. Chairman.
Excellent. Thank you very much, Senator Castley. We'll go to Senator Carter has a question. So Senator Carter, you're up.
Thank you. I'm so sorry if I was in another hearing and I missed your testimony, Senator. So I'm probably asking questions that you've already addressed. So I apologize for that. But I've been curious to know in Maryland, the gravity of this issue as a problem. And I wanted to know if you have data on the number of people that have been married in Maryland under the age of 18 and in which jurisdictions, and maybe if you had a view of like this past year, as well as like the last 5 years. And then in addition to that, of the people that married under 18, is there any data on how many of those people married substantially older people, like 4 years or more, as this bill would talk about?
Thank you, Senator. I don't have the data in the last 5 years or by jurisdiction, but I will work to get that for you in a timely manner. To answer your kind of last question, the most recent data breakdown we have is from 2019, in which 64 children were married, 10 of whom were married to someone between the ages of 25 and 29, and 3 children were married to a person between the ages of 30 and 34.
I think, I don't speak for everybody, but I think most of us can appreciate the concern with minors or marrying people that are substantially older. We have laws already that protect minors when it comes to sexual relationships or sexual issues with people that are substantially older. But I've expressed to you privately, and I'm going to also say it again publicly, one of the struggles that I have, and I proposed an amendment, but the bill, I don't think the bill ever made it to a vote when I did propose the amendment, is that in Maryland, we're very hypocritical about children. We cherry pick what circumstances and which children we choose to treat as children. And so the struggle for me is, on one hand, we would look at every single person under the age of 18 that's a minor as too immature to make the decision, a gravity of marriage, even if they have children, even if they're like a child whose parents were not there and they started taking care of their younger siblings at age 12 and basically raised them on their own, or even if they've had children, we aren't taking that into consideration. We're kind of broad brushing everybody under a certain age, too young for marriage. But we're, in some way, are we not also sending a message that, it's a way, it's discouraging marriage, even if you've had children. And that's kind of like a reversal of the way that society was when I was coming up. But that's not my point. My point is that we treat children in the criminal justice system. A child in Maryland can be arrested at the age of 7. A child can be automatically and will be automatically charged as an adult with certain offenses. And so I have a struggle with taking this category out and saying, oh, always a child, can't marry. But if you're charged with a crime, though, you can automatically be charged as an adult and go to prison for life. And so I don't think that you can address one thing without the other. We need to be very firm in Maryland about whether people are children under a certain age or whether they're not. And that needs to be consistent across the board. So I'm interested in working with you on the bill. I might propose an amendment or two, but the general, I appreciate the goal of the bill. I just want you to know that. And I do struggle though with the bright line of 17, because I actually think, well, if you're 16 and a half and you are pregnant and you want to get the marriage done, as Senator West said, before the baby comes, and you want to be able to say that I brought my child into the world and within the confines of marriage, legal marriage, you ought to be able to probably do that. So the bright line, under no circumstances, I struggle with, if you have parental consent and you've had a child and, you're mature and you kind of actually appreciate that you want to be married when you bring your child into the world. I don't know that we should say under no circumstances is that allowed.
Thank you, Senator. And I want to thank you for the many conversations you and I have had about this bill. And I appreciate your concerns. And I want to thank you for your consistency in advocating for the children of Maryland across the board. I think you did bring up an excellent point that I neglected to bring up in my testimony, which is the current law of 15 and a half, if you're pregnant and your parents sign your rights away, is a bit of a loophole in terms of our statutory rape laws. So we could have a situation where a 30-year-old is having a sexual relationship with a 15 and a half year old. And if under the circumstances of the current law could actually marry that 15 and a half year old. That's kind of the stark public policy problem in the starkest of senses. Our current law not only, allows it, it's condoned. And so this is, I think, the correct balance. And I've discussed that I've taken a lot of heat from one side who believes the bright line should be 18 with no circumstances. I can appreciate, while I don't agree with, I can appreciate the concerns about 16-year-olds. I think this bill strikes the correct balance and still gets to the heart, which is ensuring, to the extent we can control things, that people are entering into this government contract of their own free will in a way that is best for both partners.
All right, excellent. Thank you very much, Senator Elfreth and Senator Carter. Additional questions from the committee? All right, seeing none, that'll conclude the hearing for Senate Bill 29. Thank you very much, Senator Elfreth, and to the panelists. We'll now move on to Senator West, and that will be Senate Bill 161 or 17. Which one would you like to take first, Senator?
If we could do 17, because we have the witnesses in from the waiting room for this one.
So which Sandy?
17.
one?
Let's go with
Senate Bill
1.
17.
17, okay. Thanks. Thank you, Mr. Chairman, for introducing me. It's a pleasure to be here to present Senate Bill 17, which is entitled Child Custody, Cases Involving Child Abuse or Domestic Violence, Training for Judges. The United States averages 4.3 million reported incidents of child abuse annually, one of the worst records in the industrialized world. The Center for Disease Control and Prevention found that 1 in 4 girls and 1 in 13 boys will experience sexual abuse in childhood. At the onset of the COVID pandemic, reported incidents of domestic abuse in Maryland saw an increase. In 2020, there was a work group which submitted its final report. It was a work group to study child custody court proceedings involving child abuse or domestic violence allegations. The background of the work group indicated that it's been estimated that up to 58,000 children each year in this country are ordered by a court into some form of unsupervised contact with a physically or sexually abusive parent. And so this bill is intended to require that judges who are going to hear such matters in court in Maryland have sufficient training so that they can make good decisions when placing children in the custody of adults. Unfortunately, we have seen instances in Maryland courts where the judges made serious mistakes in child custody cases involving child abuse and domestic violence. Of course, this wasn't done out of malice, but by the steep learning curve associated with understanding family law. So if I could just read from the bill, it states the Maryland judiciary, in consultation with domestic violence and child abuse organizations, shall develop a training program for judges presiding over child custody cases involving child abuse or domestic violence. The proposed training includes learning about early childhood brain development, how traumatic events impacts this development, state investigatory processes and their limits, interpersonal dynamics that contribute to abusive behavior, and preventative measures to mitigate abuse, such as family protections, witness credibility, validation tools, and risk assessments. Now, under the bill as introduced in a previous year, and in fact, as proposed by the work group, the judges would have to receive 60 hours of initial training within their first year of presiding over child custody cases. This year's bill, Senate Bill 17, that's been reduced by 2/3. So judges would be required to receive only 20 hours of initial training within their first year of presiding over child custody cases involving child abuse or domestic violence. And then only an additional 5 hours for every 2 years that they continue to preside. By the way, this, remember, only applies to judges who are going to sit on these sorts of cases, so that the judge is assigned to the criminal docket and doesn't deal with these sorts of cases, no training would be required. If the judge is on some other kind of a docket, a civil docket, possibly a juvenile docket, it wouldn't be required. Only in the family court, where the judges are presiding over child custody cases involving child abuse or domestic violence, is this sort of training required under this bill. The bill also provides that the professional who's going to do the training have a sufficient amount of experience in order to conduct meaningful training for the judges. Now, there are 2 amendments that I don't think you have to the bill. One amendment on page 3 deletes the section requiring training on what's called parental alienation. This is a highly controversial area, and I think a number of the opponents of the bill are appearing today to oppose the bill because they're very upset about parental alienation. So I want to take that out of the bill and remove that as a cause for concern. The second is we're going to change slightly the description of the training of the trainers, of the required experience of the trainers who are going to be training the judges. Now, I had a conversation with former delegate, now Judge Kathleen DeMay, about 2 weeks ago. We chatted about the necessity of this bill. She indicated that the judiciary is opposed to the bill, and I now have a copy of their opposition. And I can see what their objections are. Judge DeMay and I, during that conversation, agreed that we would sit down together after today's hearing and come up with a consensus bill. And I have every reason to believe that we will be able to come up with a consensus bill. So in the meantime, I'd appreciate the committee's consideration of Senate Bill 17 and hope that the chair will hold this bill until Judge DeMay and I have had a chance to iron out the problems the judiciary has with the bill and hopefully present to the committee a consensus bill. Thank you.
Excellent. Thank you very much, Senator West. And we'll now move on to your panel. We'll start off with Ms. Hoyer. You are up. Good to see you. Let's see, I'll ask that mute. There you go.
Great. Good afternoon, Chairman and distinguished members of the committee. I first wanted to start off saying that I'm testifying here today as a work group member and not as a member of the Secretary of State's office. Some of you know me, but I'm Ann Hoyer. I've worked in the Maryland Secretary of State's office for almost 8 years now. My primary role was developing and heading up the Safe at Home program, which provides a life-saving tool for victims of violence. A large percentage of those individuals found themselves in family court custody for obvious reasons. Prior to my position with the state, I worked with multiple organizations and experts who work in the child abuse and domestic violence arena. Since 2005, I've been engaged in conversation with protective parents, both men and women, who were and are desperately seeking protection and justice through our court system. Many of these cases have a commonality, and that system errors and beliefs have left them in the same situation, if not worse. In 2018, I was honored to be appointed to the legislative group, a work group, and SB 17 is a product that came out of that work group. This group was charged with seeking out common sense solutions to address the challenges that family courts are faced with when overseeing custody cases where allegations of abuse and domestic violence is alleged. As anyone can imagine, these cases are far from easy and very complex. One of the recommendations was to provide life-saving training/awareness to judges presiding over these difficult cases. This will give them the necessary tools to assist them in making life-altering decisions for children and families, as well as alleviating some anxiety and apprehension typically associated with judges participating in family court matters. It may also protect them from a life of PTSD in the event of a decision gone badly. That being said, they need to be aware of the current scientific-based tools that are available to them. These training subject matters can be the difference between a life of abuse or in some cases death. We must support and arm our justice system with the knowledge needed to protect the children and families from a life of trauma. Resolution 72 was passed in the U.S. House of Representatives in 2018, recommending that all states put child safety as the #1 custody and parenting decision. There are 6 states currently that we know of that have already implemented mandatory training throughout the country. I want to thank you for allowing me to speak today, and I urge a favorable report on SB 17. Thank you.
Excellent. Thank you very much, Ms. Hoyer. We'll now move on to Ms. Kenny. Is Annie here?
And I'm sorry, Chairman, one more thing. I wanted to also thank Senator Susan Lee for being the sponsor last year on this bill, and Senator West for making this happen again. And thank you very much.
Excellent. Thank you. All right, Ms. Kenny, you're up.
Hi, my name is Annie Kenny, and I am a single mother to 3 daughters from St. Mary's County. In 2017, I discovered my now ex-husband had abused our oldest daughter, and he was indicted on felony child sex abuse charges and is now a Tier 3 registered sex offender for life. It took 7 months for him to be convicted of his abuse. It took me 4 years in family court to get a no contact order. For the first 2 years of the court battle, I was very ill-equipped to be understanding what was happening. I had a regular private attorney and a judge who put a lot of focus on keeping a connection between our other 2 daughters and their already convicted father. He he was granted supervised visitation at his mother's house to be supervised by her overnight, every other weekend. About a year into that agreement, it was determined that he was actually being left alone and sleeping in a room with our young 2 daughters. When I went back to court after that moment, the judge at the time, his suggestion was that we continue the visitation agreement and just tell his mom not to leave them alone. I couldn't go with that. I refused, but I just basically spent 4 years going back and forth without all of this training that's listed here. I didn't have any of that information. I didn't know any of those studies. I didn't know really anything. And I really had expected that the judge was going to offer some sort of protection to my children. But that just proved to not be the case. The magistrate, his favorite thing that he would say for every family court case was that in this courtroom, we don't divorce families, we divorce couples. And although that is a beautiful sentiment, and I understand the purpose of it at times, the fact that my ex-husband was already convicted should have carried a lot more weight with keeping my children away from him. And I really think that judges could be much more successful in what they're trying to do with some proper training. Thank you for your time.
Thank you very much for your testimony today. We'll now move on to McLeod. McLeod. There you go.
Awesome. Thank you. Good afternoon. My name is Hera McLeod. 9 years ago, my 15-month-old son, Prince McLeod, was drowned on his 4th unsupervised visitation with his father. Many who hear about my custody case are quick to dismiss it as an extreme example, but I assure you that in the 9 years that I've been studying and advocating for family court reform, I've seen a very common thread running through these cases, particularly those where children are in danger. Judges don't have the required training to properly assess cases that involve elements of domestic violence and child abuse. And if my words alone aren't compelling enough, let's take a look at what the Montgomery County, Maryland judge said in my case. I'm in family law because I have to be. It's a required 18-month rotation. I don't like it. And if I could choose not to do it, I would not do it. And it's for cases like these. Let me tell you that what I conclude this case is not about. It's a lot of smoke. It's a lot of smoke. Well, there's a lot of smoke. The difficulty is that with all the smoke, I can't see clearly. I don't have the answers. I don't have any superior knowledge beyond anyone else. What I do know is I'm going to make a decision based on the law and based on the testimony I've heard and based on what I think, right or wrong, is in the best interest of the child. Unfortunately for my son, what this judge thought, because he didn't have access to the superior knowledge he referenced, which this bill addresses, wasn't in the best interest of my son. He sentenced my son to death because of his assumptions, bias, and a lack of knowledge about how to properly assess a case that involved domestic violence and child abuse. This same judge told me that for my son's case to reach the threshold of a child in need of action, or CINA case, he'd have to come home to me with cigarette burns on his back. My son came home to me in a body bag. I'll never forget the moments I had with Prince before I closed his casket for the last time. I told him I was sorry, that I couldn't protect him, that I knew he wasn't the first child this happened to, but that I would make it my life's purpose to help ensure he be one of the last. That the next child whose life rested in the hands of the court, that child would be saved. I'm asking for all of you to take a step that those before you were unwilling to take to protect the children who will come next. SB 17 doesn't fix everything that's wrong with family court or our justice system, but it's a necessary step that would give our judges the tools required to make the right decision, the decision that would save the children who will come next. Thank you for your time.
Excellent. Thank you very much, Ms. McLeod. And obviously all of us are extremely sorry to hear about what happened. So thank you for taking the time and sharing your story and your testimony. Next, we'll move on to Ms. Cooper.
Thank you, Mr. Chairman. My name is Camille Cooper. I'm Vice President of Public Policy for RAIN. RAIN created and operates the National Sexual Assault Hotline. We serve about 27,000 people a month. For our National Sexual Assault Online Hotline, 50% of the people accessing our services there are minors. During COVID, about 67% of the children accessing the online sexual assault hotline disclosed that their perpetrator was a family member. 79% were quarantined with that family member. As a member of the Child Custody Working Group for Maryland, we spent about a year and a half studying these issues. Across the nation, Maryland's not alone here. Across the nation, when two parents of a child are divorced, separated, or never married, and acts of domestic violence or child sexual abuse are perpetrated against one parent or against a child in common, courts often rule against the parent trying to protect themselves and their children from abuse. They make custody placement decisions favorably for the abusive parent. This puts children directly in harm's way and has lifelong impacts on the child's nervous system, functioning, and development. We are aware that most judges are appointed or elected to the bench with little to no specialized training in domestic abuse or child sexual abuse. A lot of them have specialties in other parts of the law, real estate, criminal law, things like that. As a result, many of the behavioral indicators that victims and children exhibit who have experienced abuse are then misinterpreted by judges. Behaviors that are consistent with trauma often appear very illogical to an untrained person's eye or an untrained judge. And harmful custodial decisions are being made across the country in the result, and they're being made in Maryland. In family courts, the friendly parent doctrine reigns. With this as a backdrop to custodial decision-making, allegations of abuse are seen by judges as very unfriendly, sometimes even vindictive. And this leaves real abuse victims with no option but to have their fate decided by judges who are biased and emotionally reactive to the allegations from the very start. And that is not justice for victims. This gap in knowledge for judges has even proved fatal for children, as we just heard. Even in the face of overwhelming therapeutic and forensic evidence, judicial bias is so hardwired that victims and professionals whose job it is to protect victims are often met with insurmountable obstacles in their pursuit for safety and protection. For these reasons, we would ask you to please support this bill.
So thank you very much, Ms. Cooper. I will now move on to Ms. Montgomery.
I don't see her in the waiting room.
Okay, excellent. Then that will conclude the testimony for the proponents of the bill. We'll now move on to the opposition panel, and we'll start off with Ms. Lenning. There you are. Welcome.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Dorothy Lenig. I'm the director of the Domestic Violence Legal Clinic at the House of Ruth. The House of Ruth serves victims of domestic violence throughout the state. I'm actually not in opposition. I'm support with amendments. We're urging you to amend it to the bill. So on page 2, starting on line 3, to just strike the rest of the bill. This would leave the requirement of judicial training, but take out that long list of topics that judges have to be trained on. I've done a lot of training for the judiciary over my many years at the House of Ruth, and the thing that I've really come to understand is that you have to stay current with the new developments and the new research. If we had that whole list of items that had to be trained on, and you wanted to add in all the new topics that you train on, it would be more than 5 hours. When I started practicing a long, long time ago, everybody agreed that in a family where there was domestic violence and dad was beating up mom, for example, but he wasn't beating up the kids, that there was no impact on the child or on the children. And it was fine to send the kids off with dad for visitation. Over the course of time, the research bore out that the traumatic impact on the child was exactly the same living in a household with domestic violence, whether or not the child was being abused or not. So the physical abuse was not the traumatic impact, it was living in the family. So at the time, that was considered new research, and we would have wanted the training to change along with that. I participated in a judicial training as recently as October of 2021. We just did a training for judges on the impact of domestic violence and trauma on children and on parents. And at that training, the topic I was asked to train about was why victims who have been traumatized, including victims of domestic violence, often make very bad witnesses. They have a really hard time telling the story of the abuse in a logical, linear way. They're either too scared of the abuser or they're feeling the effects of invasive thoughts, and they have trouble telling the story logically. In a domestic violence case, the judge has to determine whether there's been domestic violence in that family, because if there is, you want to make sure that the access arrangement allows the child to be in a safe, secure situation so that they can start to heal. If the parent can't tell the story, then the judge has to be able to elicit the information in another way. I don't see that topic on this list of required training materials. So I think we need to give the judiciary the flexibility to have the topics in there that they believe need to be trained on, the judiciary and the experts. So for those reasons, we urge a favorable report with amendments. Thank you.
Excellent. Thank you very much, Ms. Lenig. We'll now move on to Ms. Ruth. See you there.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. Thank you for having me here today. Two brief notes. I believe you may have Melanie Shapiro from the Maryland Network Against Domestic Violence also here to testify favorable with amendments as we are. She's in another meeting and can't be here, but you have her written testimony. Similarly, the MSBA Family Law section submitted favorable with amendments. I gave it to Ms. Pop earlier today. They missed the deadline by about 5 seconds, 3 o'clock 2 days ago, but their testimony is worth reading. We also, as I said, come in favorable with amendments with essentially the same amendments that Ms. Lenig just suggested. Senator West says they want to change the definition of trainers. I can't really speak to what they're changing, but you know, I think that it's really important to offer training to the judges, but I think it's also important to leave it to the experts that are mentioned in those first few lines of the bill to let them develop the curriculum and let it adjust as new things adjust. In conversations on this bill, and not to make light of things at all, I just kept thinking about eggs. When I was young, eggs were good for you, and then they were bad for you. And I think now they may be good for you again, but research changes, social science research changes, vocabulary changes, the way things are titled. Another one to think about is autism. We used to have different words for that, but currently I think we say somebody is on the autism spectrum or they have autism spectrum disorder, but it used to just be that a child was autistic. So if you highlight everything like this bill does, every time something new happens, what if they change the term ACEs? 15, 20 years ago, we didn't say ACEs, but now we do, but it could change again. And it's practical reasons, but also allowing the judiciary the ability with experts to develop the proper curriculum for the training of judges. A few smaller issues. I am, relieved that the number of hours was changed from last year's 60 hours to this year's 20. However, that was also not designed by experts. That was designed by well-intentioned people on the work group of which I was a member. And I would, again, leave it to the experts to work with the judiciary over time about how much training would be the most valuable for judges. And another thing is that the bill doesn't mention magistrates. I believe others may think district court judges should also be included in this. Certainly magistrates are all over family law cases. So for those reasons, we would ask for a favorable with amendments report from this committee. Thank you so much.
Excellent. Thank you very much, Ms. Ruth, and thank you for the clarification with favorable with amendments for the last three witnesses for Ms. Lenig, and then also with Ms. Shapiro, who is not here, but we have a written testimony in our file. So now we will switch over to the opposition panel, and we'll start off with Mr. Eichenbaum. I think I saw you come into the room. I think I saw you populate in here. There you are.
Can you hear me?
We can.
Okay, thank you very much, Chairman Smith. First of all, I wanted to thank Senator West for letting us know that the removing parental alienation from the bill, that obviously was a very serious concern. And I really believe in the intent of this bill is really great, that judges do need better training in this area. But my reservation is in who are the people who are going to be designing the curriculum. And so a way of introduction, please consider the following points. This bill is largely a result of Joan Mayer's study about domestic violence in the court system. So isn't it curious that this groundbreaking study about domestic violence was never published in an American peer-reviewed journal? Also, her methodologies and research model was strongly refuted by a peer-reviewed article in the APA's magazine, or journal rather, Psychology of Public Policy and Law. Why didn't she respond with rebuttal in this journal as is customary in journals of this caliber? Also, why is she concealing her research data? In one of her papers, which is in my written testimony, she provides non-existent links to her data or links that have restricted access. And why wasn't the National Institute of Justice, when it was asked to investigate these things and other research fraud, they just kind of blew it off and didn't pay attention to it? So even if specific references to parental alienation are removed from this bill, I have really serious reservations about relying on her recommendations of what the curriculum should be and what should be included in it. It makes me very nervous that there's not a balanced picture over here. So I invite you to take a look at my written testimony and the documentation that's there to see what the actual science says and to make an informed decision about whether we're really dealing with all the information over here. And I also urge you to convene a panel of domestic violence experts and shared parenting experts in these fields to make a proper presentation on the science. And I can provide you with contact references for that. Thank you very much for listening. And if anybody has any questions, I'll be happy to answer them.
Thank you very much, Mr. Eichenbaum. All right, although we've moved to the opposition panel, do go back to favorable with amendments. I see that Ms. Shapiro is here, so I want to give you an opportunity. Ms. Shapiro, go ahead.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. I am Melanie Shapiro. I'm the Public Policy Director with the Maryland Network Against Domestic Violence, the state's federally recognized domestic violence coalition. And I am testifying favorable with amendments on this bill. I will not reiterate what many of my co-panelists have already testified to regarding the need to remove all of the language pertaining to different types of testimony regarding the specifics as the science changes, as best practices changes, with the right people being consulted with. Those trainings should be more than sufficient. I did want to also suggest that the training be extended to include magistrates and district court judges as well, as this is specific to child custody, but magistrates may not be included, yet they often oversee family law matters. And in addition, district court judges in protective order proceedings can make decisions regarding child custody in the context of domestic violence. So for all of those reasons, we urge a favorable report with amendments on SB 17. Thank you.
So thank you very much, Ms. Shapiro. We'll now move on to the opposition panel, and we'll start off with Mr. Field. Michael. Mike, there you are.
Thank you so much. And thank you for giving me this opportunity. And most importantly, I'm thrilled to hear that the parental alienation section of the bill is out, and that takes a lot of wind out of my sails. But in case there's ever a thought of it coming back, I needed to say this. On September 21st, 2015, I lost my son. He's alive, but my family and I are dead to him. He lives 6 miles away from me, but he might as well live on another continent. We never see him. He doesn't communicate with anybody in my entire family. I attend his extracurricular and school activities, or at least I used to. He ignored me. I send him texts, emails, phone calls. To this day, he never responds. I send him gifts. He doesn't acknowledge receiving them. We had a great relationship right up until the day my ex-wife took him from me. And there's never been accusations in any abuse of my son or my ex-wife because there never was any. This is what parental alienation is. In August of 2008, I caught my wife having an affair. We had been married for 6.5 years. We had one child together biologically, and I adopted her child from a previous relationship. I found out in August 2008 that she was sneaking both of my children around with another man behind my back and introducing him to them. My biological child immediately refused to see or communicate with me. I'm sorry, my adopted child refused to do that. Before the divorce even occurred, my wife had both of my children calling that man Daddy Peter and me Daddy Mike. She listed the man she was having an affair with as the father on school documents, not me. She told both kids I was not the father when I tried to go to a soccer game for my legally adopted child, right in front of both of them. I had evidence that my ex-wife continually violated the court order by having my kids stay at her boyfriend's house in a one-bedroom apartment instead of at our house. At the divorce hearing, the judge said, I don't even want to hear anything. I'm giving other primary custody, and if the father tries to fight that, it's just going to be worse for him. 1 month later, a card came to my house, a soccer trading card with my biological son, his name with the man she was having an affair with, that man's last name as my child's name instead of my name. We went back to court in April of 2010 as a result of all of the things I've already told you. The judge granted me legal custody, sole legal custody, primary physical custody. It didn't matter. 5 years later, on September 21st, 2015, she literally took my son from me. I have not had any relationship with him since. My son with my current wife was 2 years old at the time. He has not seen her since. He has no memories. My son is about to graduate high school. He's about to turn 18, and I have not seen him since in 6.5 years. Parental alienation is real, and it is child abuse, and it's devastating to everyone involved, most of all the child. Thank you for removing this from the bill, and please don't ever consider placing it in any bills in the future. Thank you.
Excellent. Thank you very much, Mr. Field. We'll now move on to Mr. Kammer. You're up.
Thank you. I too am very happy that the parental alienation section has been removed. Like others have said, that was primarily what I needed to talk about. By the way, I want to mention that I am not a father. I've never been alienated from children. I'm speaking as a retired social worker. So the parental alienation section has been removed. I also like what Ms. Lenig said from the House of Ruth about removing lots of other language about what was going to be trained. And that makes me feel better. But I would like to ask or offer to Senator West, to request to Senator West, very grateful that you removed that misguided section on parental alienation. Would like to point out that there is still a problem with the bill because it has the DNA of the working group. And it was the working group that provided that bill with which had to have so much bad material removed from it. And I would love to have some assurance that the people who work with you to decide who is going to be trained, who is going to conduct the training, will not be just people of the same type as populated the working group. Domestic violence, for instance, is highly ideologically pursued. Many ideological points are raised and bandied about. The science is often very much at odds with what is in the culture. And so I'm sure that Rabbi Eichenbaum, I know Vince McAvoy would be very happy to help you. I would be very happy to help you make sure that the training that we're going to put together is not ideological, is not biased, is not prejudicial, and protects children against all forms of abuse, not just the kinds that fathers more likely than mothers perpetrate. Would love to know if you're interested in that, Senator West.
I think I've been unmuted.
Sorry, excuse me. Sorry about that. Sorry. We don't allow questions from the panelists to the
Okay,
senators.
I'm sorry, I withdraw that.
Strictly a one-way street. All right. Yep.
I'm sorry. Yes, sir.
All
Okay,
right.
very well. I'll just leave the offer out there. I would like to know from the chairman, after these amendments are finalized, will we have another chance to testify on the final or on the new revised bill?
No, this is the bill hearing for this bill.
So we have no idea what the amendments will be.
You can watch online and you can come to Annapolis, but you will be able to solicit your input through email, phone calls, and other methods of reaching out to your legislator, to your senator.
Okay,
Thank you very
suddenly
much, Mr. Kimmer. Thank
Suddenly
you.
I don't feel so good anymore. Thank you, sir.
I appreciate it. Thank you very much for your testimony today. All right, Mr. McAvoy, you are up next. There you go.
All right, thank you so much. Committee, what was just discussed is something that needed to be and has been discussed with various senators and chair's office, and this one and previous with various senators, and even when they were in the House. For a decade, I've watched this process go on, where new people get wrangled up, they're told about a heinous thing that's going on, and that we have the answers. For once, the people that sit in all these domestic violence case bills, the ones that are elected to train the judges, have actually said, you know what, we're going to erase our work, because you have people who call them to the carpet. Mayor's work is garbage. And you've had people testify and give you detailed in the written. I'm not going to cover that. We understand the parental alienation's out. But as was just discussed, the DNA of this bill, and it's not just this bill, is it? It's another bill right after this. We have a couple in the House, and I think we have one more coming. What I'm trying to say is, in 2019, I came before the committee and I said that this was an agenda piece, this SB 567. And it is, and it has been. And in the testimony you actually see the email where I wrote to this committee, to the Secretary of State saying, if not me, you need to get a father on this bill. Your colleague put that amendment to SB 567. They ignored it. And guess what? Look at how the result came out. These things, honestly, hopefully will cause the bulk of your committee to take a step back and say, look, now we see that we've been delivered garbage year after year, the same kind of diatribe, the same kind of unprovable statements that just aren't consistent with the statistics that we actually have for the state of Maryland regarding domestic violence, which is a very small part of what goes on in parenting, where they try to portray a large number of parents as deficient. So as was previously offered, I, of course, would welcome working with your committee to have something that is balanced for the sake of children and dads.
Excellent. Thank you very much, Mr. McAvoy. So that'll conclude the testimony for the opponents. We do have one last member, Mr. Wobensmith, who is a proponent. So we had technical difficulties getting him in earlier. Welcome, Mr. Wobensmith. So ask to unmute you here. There you go.
Thank you very much, Mr. Chairman, members of the committee. It's been an interesting listening to some of the words that just occurred. By the way, I'm here testifying as the chair of the work group that was set up in 2019 to study child custody cases involving child abuse and domestic violence. One of the things I would point out is that we had on that committee Senator Susan Lee, Senator Mary Beth Carosa, Delegate Atterbury, and Delegate Jazz Lewis. They were very much a part of that, and they played actually a very direct role in both the leadership within that, as well as the recommendations that came out of it. And we did study those for a long period of time, a year and a half. And we talked to lots of different people. And there were opportunities. We did public testimony. Anyone could come in and sign up and appear before us. We, as I say, we had many different views that were presented and lots of information. What we're looking for with Senate Bill 17 is a slimmed down bill from last year that does address the most fundamental and important aspects to really help our judges make better informed decisions. And, you know, when reflecting on this, one of the things that occurred to me is it really does seem to me that our Maryland children, just like our other citizens, have a fundamental right to life, liberty, and the pursuit of happiness. They have the right not to be put into a situation where they can be killed or raped or molested or be subjected to other physical or mental abuses, something that we know affects them throughout their entire lives. And we have heard lots of tragic cases here, and we heard some today, and we heard many others, and we had with our committee, with our work group, we had lots of people that came and testified about all the abuses that are occurring. And we know that hasn't really changed. As we had, you know, as we heard really during the pandemic, we had children calling in and expressing the same problems and the same tragic circumstances that we've heard about now for many, many years. I think we have a duty to protect those seriously at-risk children. It is a fundamental right. It's a fundamental right for them. And if we ignore that and just let this go on as it's been happening,
Time.
you know, where are we? Where are we? How many more children have to die before this becomes something that is acted upon? And I, you know, that certainly as far as the education is concerned, that's something that, again, the judiciary can make the decisions on who they would be doing, bringing in and have the right people coming in to do that kind of training that's necessary. So I strongly support and ask your support for Senate Bill 17.
Thank you very much, Mr. Wilson-Smith. And with that, that'll conclude the testimony for Senate Bill 17. Let's turn over to the committee for questions. We've got one from Senator Castley and then Senator Carter. Just real quick, because I know that folks may have to peel off. Just look, most of the bills that are submitted, we'll get a hearing, get one hearing. And then after the hearing, the bills will be scheduled for a vote. That is all public. You can follow that on the JPR website, the Maryland General Assembly website. When you see that it's been scheduled for a vote, that is your time to spring into action and contact your legislator, your senator. So that's where the follow-up advocacy can happen. This is the one and only hearing for the bill. So that's just generally the way the process works. So we'll switch over to questions now. Senator Castley, and then we'll go to Senator Carter. Senator Castley.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. It's really a question for the sponsor, and that's whether, I guess, goes out saying that no member of the judiciary was on this panel, right, or on the work group.
No, I
Senator
don't.
Lee was.
Yeah, but the question was a member of judiciary. I don't think so.
I didn't mean the judiciary committee. I meant the branch, the judicial branch.
Yeah, I've got the work group report. I don't see a judge on here.
Right. So did the group review the current training touching on this area that's offered by the Judicial Conference?
I wasn't on the work group, so perhaps Secretary Wilson-Smith could answer that.
Okay.
Or Ann Hoyer, they were both there. Senator Lee was too, if she cared to jump in.
Senator Lee, I'm happy to answer it if
Sure.
Senator Lee is in a hearing in finance.
Okay. John, why don't you try to answer his question?
Sure. First of all, we did invite the judges to be part of this, and they chose not to. We did have, actually, many of the judiciary came to the hearings and took notes. And so they were there listening to it, but they were not participants. They chose not to be. And I'm sorry, what was the other question?
Whether you reviewed the training that's currently offered by the judiciary in this area?
Again, right. We actually asked them to provide that, and the judiciary did not provide that to us.
Okay. I guess a question back to the sponsors that, I mean, we know that judges are picked from all areas of the law. Some of them are contracts lawyers, some of them are real estate lawyers, some are civil litigators, some accomplished criminal litigators. And we know that they all get thrown in the mix and they try rape cases and murder cases and child abuse and child assault cases. We rely upon the training that's provided them through the judiciary. Are we now going to, as a legislative body, are we going to now be basically setting up the training for the judiciary in all of these areas? Is that where this is leading?
I don't know where it's leading. I will say that my understanding is that about half of the cases these days that are in the circuit courts are family law cases. And there's a huge need for more family law lawyers to be appointed to the courts. Most of the lawyers on the courts came out of the state's attorney's office or the public defender's office. There are very few people who came like Judge Dumais now is, the family law section. So this is, we have a lack of experience on the part of the circuit court judges in key family law issues. So this is an attempt to rectify that. I'm not sure that I would support requiring judges to be trained in elements of criminal law or estates and trust law, that sort of thing. The judiciary has their own training organization, and unlike lawyers in Maryland who do not have to take CLE each year, judges do have to take training. The purpose of this bill is to point the judges in the direction in which more training is needed for that subset of judges that's going to be sitting on these sorts of cases.
Did anybody just simply make an attempt to provide the judges with the recommendations and see whether they would consider incorporating any of that into their regular training requirements?
Again, I wasn't on the committee, the work group. So Senator Lee, I see you've joined us. Do you know whether or not the work group product was provided to the state judiciary?
Yes, it was. It was. And we reached out to them, but as you indicated, they did not participate. I just want to say that several states have already passed legislation that requires the judiciary to develop and implement such judicial and court personnel training programs. So it's not anything new. For example, California law requires the Judicial Council to establish judicial training programs for individuals who perform duties in domestic violence matters, including, but of course not limited to judges, referees, commissioners, mediators, as others deem appropriate by the Judicial Council. You know, in California, it has training programs that must include instruction in all aspects of domestic violence, including but not limited to the detriment of children. And under the Connecticut law, the judiciary is mandated to create an ongoing training program for judges and other court personnel, including Court Support Services Division, personnel guardians ad litem, and clerks regarding the function of family violence intervention units and the use of restraining and protective orders. So in New Hampshire has a law that requires. Oh, go ahead. I'm sorry.
I want to make sure we have a chance to converse over this, but I don't want to accidentally turn this into a voting session. So if Senator Castley, that answers your question.
Yeah, no, just briefly, I'm looking at, I'm not aware of any, we have laws out there that require training in the judiciary, and that's how they have the Judicial Institute, and they provide training. I'm not aware of any current laws that say, oh, and here's how you're going to train. You're going to talk about the dynamics and effects of child sexual abuse, including grooming behaviors and disclosure on child sexual abuse based upon the development stage of the child, including et cetera, et cetera, et cetera, et cetera. Do we have any laws out there that sort of tread wholesale into the judicial prerogative to train their own people in such a broad or specific fashion and tell them what they're going to train, as opposed to say, you develop a training regimen in child abuse, child sex abuse, domestic, divorce, etc. Is this the first time we're doing this?
Yes, Senator, again, Ann, you look like you'd like to answer that. Wait a minute, Vice Chair Wall-Stricker, could you unmute Ann Boyer?
Can you hear me, Senator Castley?
Yes, now I can.
So as you know, I was on the work group, and these subject matters are merely a template because from what I'm aware and through our tenure through working through the work group, there wasn't any specifics in the training currently. It's more or less, and I'm not undermining the training as it stands today, but it's more or less a 101 domestic violence, child abuse. So specifically, I'm just going to use an example of child sexual abuse that is very, as I stated earlier in my testimony, it's very complex. So you really need to have a judge or magistrate, whoever's overhearing this case, to understand the dynamics of what they're viewing in their courtroom and understanding. And if I can give you a little bit of an example, for instance, if a judge gets a report from Child Protective Services and Child Protective Services says it's unfounded or unsubstantiated, that doesn't necessarily mean that child sexual abuse did not occur. So I'm just giving you that example. These are very well thought out subject matters, and a lot of these I don't believe are going to be changing. They may evolve. That's why we have the every 2 years, 5 hours for involvement. These professionals and experts who are going to be training are going to be with judges to come up with a curriculum that makes sense, that is current. So I heard some opposition in terms of, it's ever evolving, but these subject matters that we came up with are pretty cut and dry that are not going to be making much movement. We didn't go into specifics like, oh, if it changes that, this is set in stone here. We need to build upon that. These are just basic stuff that a judge have the toolbox to be able to, as Hera McLeod stated with her judge in the case that oversaw her case with her son being murdered. He had no tools. He didn't understand the dynamics of how this works. And that's really, it's pretty simplistic and common sense to have education for these people, just to help them as well, to help all of us.
It's just, I'll just be blunt that, looking on page 4, there's a difference between training and sort of advocating. And I think this bill, I'm concerned, crosses the line into advocating. When we talk on page 4, that the trainers have to have at least 5 years experience of working directly in the field of child abuse prevention and treatment, and 5 years working directly in the field of domestic violence. The only people that have such training are people who are advocates with regard to child abuse and domestic violence. So to allow one side in litigation to have hours every year just unscripted with the judiciary, I can see why the judiciary is pushing back with concerns that we are crossing into their prerogative, that we're crossing the constitutional lines, and basically allowing advocates for one side to have special presence with the judiciary that's not going to be allowed to the other side. So the judiciary, unlike us, the judiciary has to be fair. We don't have to do that. We can just put on the advocates for one side and pass bills that totally favor one side. And that's acceptable in the legislative bodies, but it's not acceptable in the courts. They're supposed to be neutral and detached. But anyway, thank you very much, Mr. Chairman. I appreciate your time.
Thank you, Senator Castley. Any other questions from the committee? Senator Carter.
Thanks, Mr. Vice Chair. So Senator Castley addressed one of my questions because I was looking at the opposition from the Maryland judiciary, and I think there's something to be worked with, but they argue that the current structure of the bill and what it calls for could lend to criticism for impartiality. So I think that should be taken into consideration as we look at possible amendments. But the other thing I had was at the very beginning, Senator West, seems like an hours ago when you first testified. I actually thought, and I think I spoke to some of the advocates about this before. Like, I think all training, additional training is necessary, it's good, and they should have training. I kind of take a little bit of issue with training specifically for this group of judges. First of all, judges rotate, so you might sit in family court for your term, and then you sit in criminal court, and then you sit in other civil court. But I think it should be incorporated into the training for all of the judges that potentially could rotate into the family court, because I don't like the idea, and I also don't know if I like the title of the bill. If it says like trained on allegations, I think they should be trained on the subject matter, which should prepare them to deal with allegations. They shouldn't, if it says something about trained on allegations of, I don't think that would be good. Well, I heard you were the advocate say that. I'm not sure if it says it or not. So those are my thoughts. I don't actually agree that with the testimony that it should be extended to all district court and other places. I think if we're trying to get at custody and visitation issues, it should be where custody and visitation is determined. I understand the protective order, but you can appeal those to the circuit court. And if there is a circuit court case, then they are usually sent to the circuit court to deal with that in the circuit court case. So those are my thoughts.
Thank you, Judge, Senator Carter.
Those are my, okay.
I almost said Judge Carter. Thank you. Thank you.
That was great.
I'm not sure whether you were there at the very beginning of my testimony, but I mentioned that Judge Dumais and I had talked about this about 2 weeks ago and had agreed that after this meeting, we're going to sit down. I know this, the judiciary has some concerns about this bill, and Judge Dumais and I agreed that we would somehow achieve a consensus. And I asked that the committee hold this bill until I was able to get back to them with the product of the conversations that I will be having with Delegate Dumais.
Wonderful. All right. Any other questions from members of the committee? Seeing none, that concludes the hearing on Senate Bill 17. We'll next move to Senator West, your other bill, Senate Bill 161. Senator West, you are muted.
I know, I always forget to do that. Thank you, Mr. Chair. And this bill is going to be shorter, considerably shorter, I think, than the last bill. Unfortunately, this bill is complicated. So let me start off and try to set the stage for this bill with the following example. So there's a bridge construction project in process on the Baltimore Beltway. A concrete mixer enters the project site and inadvertently backs into a stack of structural steel beams, knocking them over and seriously injuring a construction worker. Normally, litigation would ensue between the concrete company, the construction manager who employed the worker who directed the concrete truck operator to back up, perhaps the steel fabricator for storing the beams in the wrong place. It is highly unlikely that in such a situation, the engineering firm that designed the bridge would be involved in the litigation because the engineering firm played no role whatsoever in the accident. This bill is necessary because in certain situations, the owner of the land or the prime contractor for the job inserts a provision in its contract with the engineering firm or the architectural firm, in any case, one of the design professionals, stating that the design professional would indemnify the owner or the prime contractor, as the case may be, for all of the damages and expenses associated with a loss on the project, irrespective of the fact that the design professional firm was not the proximate cause of the loss. So in the case of the concrete mixer accident, the indemnification provision would force the design professional to pay the damages, even though it had nothing to do with the accident. Now, of course, each design professional firm has its own insurance. but insurance companies issuing insurance to design professionals refuse to reimburse the design professionals for any indemnification payments in these kinds of situations because the losses weren't proximately caused by the design professionals. So in these situations, the design professionals, engineers or architects, end up shouldering the burden of paying all of the losses from an accident, like the concrete mixer accident, including all of the attorney's fees associated with the case, even though the design professionals were not the cause of the loss. Fortunately, contracts containing such clauses are not customary, but some Maryland state procurement contracts and some other construction contracts used by very large construction companies contain such indemnification provisions. These are de facto contracts of adhesion because the design professional firm knows that if it wants the work, it will have to sign an unfair contract. Large architectural and engineering firms, large firms, may have the resources to execute such contracts and take the risk of having to pay for someone else's negligence. But for small architectural firms and small engineering firms, a contract containing such an indemnification provision is a bet the company moment. If the firm wants the work, it will have to put the very existence of the company at risk by signing a contract containing such an indemnification clause. That's wrong. That's not in the interest of the state of Maryland. That's not in the public interest. Current Maryland law provides that in a provision in an architectural or engineering contract purporting to indemnify the other party to the contract for damages arising due to the sole negligence of the other party is against public policy and is void and unenforceable. So what Senate Bill 161 does is to add language to the existing statute stating that a provision in an architectural or engineering contract requiring the design professional to indemnify the other party to the contract against loss is void and unenforceable unless the fault of the design professional is the proximate cause of the loss. So simply stated, under this bill, the design professional can only be required to indemnify the other party to a contract if the fault of the design professional is the cause of the loss, but not if the design professional was not the cause of the loss. Now I understand, I talked to Jerry Evans, I think it was yesterday. He represents some folks who have some problems with this bill. And once again, just in the case of the last bill, I agreed with Jerry that I would sit down with him following this hearing and see if we can't work out the problem, whatever the problems his clients have. So I would ask the committee to hold the bill, at least briefly, until Jerry and I have a chance to talk and to see whether or not an appropriate amendment can't be prepared to the bill, which would satisfy his concern. But with that, I turn the bill over to the good auspices of the committee members and would be happy to answer questions.
Thank you, Senator West. Let's take the witnesses and then we'll circle back. The first witness to testify, and I apologize if I mispronounced this, is Ms. Shamir Lassane Matthews.
No, that was great. Thank you. Good afternoon. So more than 40% of ACEC Maryland member firms are either small or minority-owned firms. And so I work for one of those firms that Senator West referred to. It's a woman-owned company in Howard County, established in 1996. I've been there for 19 years, and I've watched our company grow from 15 to about 90 employees. The vast majority of our work is located within Maryland, and our mission is to advance sustainable and resilient communities. We provide a ton of services, usually as a subcontractor on larger contracts. So as a small business, we are disproportionately affected by this unfair business practice. So when we get a contract, we have the choice, a terrible choice, to either accept the duty to defend provision or turn work away. And if we take on that uninsurable risk, that could mean going bankrupt. A company of my size, of our size, we can't reasonably take on an equitable amount of liability. So, and we have like no control over it. So if there's a serious problem, the potential damages and costs could jeopardize our jobs. If you pass this bill, it will alleviate the unjust situation where a firm like mine will feel compelled to avoid some contracts when the clause presents an uninsurable risk. We currently provide high quality professional services, and we want to continue to do so. But with these kind of business practices, I'm afraid it could possibly impact the quality of services, as companies like mine might go out of business, and then you'll have companies who are more adept to taking uninsurable risks come up that might not be the same quality. So thank you very much for your time today, and take care.
Thank you for your time and thank you for your testimony. We'll now go to Mr. Dennis Simpson. Mr. Simpson, you're up. Mr. Simpson, you're going to see something on your screen that asks you to unmute. There you go. Go ahead. Mr. Simpson, can you hear me? You are unmuted and we're ready for your testimony. All right, it appears that Mr. Simpson does not have audio. Let's go on to JB Osborne and we'll circle back to Mr. Simpson.
There you go. It wouldn't let me unmute. Thank you, Vice Chair and members of the committee. JB Osborne, General Counsel for a large engineering firm, mid-sized engineering firm headquartered here in Maryland. I deal with these provisions on a daily basis, negotiating contracts and reviewing contracts for our firm and of course with ACEC, support the legislative committee. This bill will improve the business climate and viability for design professionals, namely architects, engineers, surveyors who practice in Maryland, who ultimately do bear responsibility for the integrity of their design, but without making themselves the insurance company that is required to bear the risk for risks that they cannot themselves insure. There's been some misunderstandings or perhaps miscommunications through some correspondence I believe that this committee has received in opposition of the bill. As Senator West said, you know, we're happy and actively reaching out to anybody who has expressed opposition to the bill. But let me just state that nothing in this bill is intended to, nor does it have the effect legally or otherwise of allowing design professionals to escape or avoid liability for negligent design errors or omissions or their breach of the professional standard of care. What this bill does is it simply expands upon the existing anti-indemnity statute to make it clear that when a contract with a design professional attempts to hold that professional responsible for defending other parties in lawsuits, regardless of the merits of that lawsuit and regardless of the ultimate legal responsibility in that lawsuit, that contract goes too far as a matter of public policy. The current statute recognizes that insurance companies are precisely in that business. That is to say, the insurance policies cover certain risk in exchange for a premium. That's what the underwriters do for a living. The insurance carriers assume not only the responsibility to indemnify, i.e. to pay or reimburse or to pay on behalf of the insured any damages that they cause, but also a duty to defend the insured against lawsuits, whether or not the insured is legally responsible for it. That's what the insurance companies do. Design professionals are not insurance companies. And many of the folks in opposition or many of the provisions that we've read related to the opposition seem to want to hold design professionals to the tune of writing an insurance agreement for the client. And so with that, I'll just say, you know, design professionals are not insurance companies. We certainly, you know, don't want to advocate responsibility for design services, but we do ask for a favorable recommendation on the bill. Thank you for your time.
Thank you, Mr. Osborne. Let's now return to Mr. Simpson. Mr. Simpson, you are up. So we cannot hear you, Mr. Simpson. We'll try this. We'll try this one more time. We'll go to Mr. Faison. If you could unmute Mr. Faison, and then Mr. Simpson will return to you one final time after this.
Thank you, Vice Chair, Senator West, and members of the committee. I'm Chad Faison, the Executive Director for the American Council of Engineering Companies of Maryland. ACEC of Maryland represents 93 engineering firms and affiliates, which employs over 7,000 Maryland residents. Of those 93 firms, over 30% are WBE or MBE companies. As Camara referenced, she is one of our members in a WBE. Our member firms range broadly in size and disciplines, but all of them are very concerned with taking on uninsurable risk, which is why this bill is so important to us. I also wanted to reference what Senator West said. We are working with Jerry Evans and the Maryland Transportation Builders and a Materials Association, and we are optimistic we can resolve their concerns. So with that, I'll say I hope for a favorable report, and I'll yield any of my remaining time to our members and experts. Thank you all.
Thank you so much for your testimony. We'll try one more time for you, Mr. Simpson, and we apologize if any of this technical difficulty is on our end. Go ahead, Mr. Simpson. So we cannot hear you, and again, our apologies if it's on our end, but we do have your written testimony. We'll make sure we distribute it to the committee. With that, we'll see if there are any questions from the committee for the sponsor or for the witnesses. Senator Sitnor.
Thank you very much. And this is for the sponsor. So in section, on the last page of the bill, it says this subsection may not be interpreted to prohibit an otherwise enforceable indemnity or hold harmless provision in any contract or agreement. I'm curious, because as I've listened to the arguments, I think many of the arguments that have been made aren't necessarily specific to this industry, but just to indemnity provisions, period. I know in my line of work, I see a lot of these provisions and think some of the same things. So I'm curious, do you believe that there are times when, or do you think this whole concept of indemnity agreements is something that we should look at in total, or should we be doing this piecemeal industry by industry?
Thank you, Senator Sidner. I'm not aware that these indemnification provisions are being used in other. When I first got this bill and took a look at it, I thought, wow, is this the kind of stuff that's prevalent throughout contracting?
Yes, it is.
Well, not this kind of indemnity. I'm a business lawyer, and I've spent an awful lot of time reading and writing contracts, and I had never read provisions this onerous that required someone who had no connection with an injury, with a loss or an injury, to pay for people's litigation expenses and then pay for the loss, the damages itself. And I'm persuaded that the language that is targeted by this bill is fairly unique to the construction industry and to design professionals. In terms of whether this bill has more widespread applicability, the term design professional is defined in the bill. And when you get into the dispositive provisions of the bill, it specifically refers to design professionals. So this is not a widespread bill trying to cover.
Right, that which goes to my question. I'm wondering if your thinking is that, I mean, it should just be limited to this industry, or if we should be getting rid of the whole concept of indemnity provisions and contracts.
No. And okay. Indemnification is fine when the design professional was responsible.
But in that case, that'd be direct liability. I mean, you would need an indemnification provision, would you?
Well, JB, why don't you jump into that? You who represents these people. Go ahead. Can we unmute JB for that question?
Thank you.
Sure. Thank you, Senator. And it's a valid concern and a valid question, Senator Snyder or Sidner. The issue for design professionals and what makes design professionals unique, unlike general contractors or any other industry where indemnification provisions are prevalent. You're absolutely right. They are prevalent in contracts for myriad types of services and even goods, right? You're purchasing goods, and if something product liability, something goes wrong with the good, the manufacturer should stand behind it and cover any claims that arise from it. Most businesses, those liabilities are covered under general liability insurance products that are available to business owners. So general liability insurance covers really three things. It covers property damage, bodily injury, and what they call broad form contract liability, which is, I'm not an insurance expert, but wherever you assume the tort risk or the tort liability of another party by virtue of a contract, the policy will step in and provide coverage for that. General liability insurance policies exclude, one of the exclusions under those policies are any claims that arise out of the performance of professional services, i.e. services performed by architects, engineers, and land surveyors, landscape architects. So we rely on our professional liability insurance to fill that gap in risk. And the professional liability insurance includes its own exclusion, which says we will cover the legal liability of the architect or the engineer, but we will not cover any contractual liability that you assume that you would not have in the absence of the contract. So we get stuck having to sign an agreement that requires not only indemnity, but also that upfront duty to defend our client. And we can't transfer that to an insurance company the way that a typical business owner in any other line of work, most other lines of work, I should say, are able to actually tender that to their insurance carrier and to provide that coverage. So we get stuck sort of self-insuring that risk. And it, you know,
and does this bill not only cover indemnity, but is also that duty to defend?
Yeah, and that's a good point. Is the bill is twofold. One, it as Senator West alluded to, it attempts to narrow the confine of what a valid indemnity provision is allowed to cover against, to tie it to legal liability. So indemnity is valid to the extent the architect or the engineer is legally liable. But if it tries to hold the architect or the engineer liable for something for which it wasn't their fault. So in the hypothetical, if it was the truck that knocked into barriers, it really should be the truck driver or the contracting company who's paying for those damages, despite any contract provision that tries to hold the architect responsible for any claims on the project. The duty to defend is really the piece that we have the most heartburn with, because that forces us, before anybody has established fault, the onset of the claim, everybody is sued. Right. In that hypothetical, everybody that ever touched the project is sued, and everybody should be relying on their own insurance carriers to assign counsel to defend that claim, right? Rather than looking at the agreement and say, who can I send this to? And ultimately it becomes that architectural contract or that engineering contract where the lawyers look at it and they say, well, we can send this one to the architect and they can pay for the legal fees. Doesn't matter if they're at fault, they agreed to assume a duty to defend. And naturally, the duty to defend happens before liability has been established.
Right. Okay. Look, thank you.
You bet.
Thank you, JB. And you answered that far better than I could have.
Not a problem.
Thank you, Senator Sidnor. Thank you, JB. All right, we'll move on to Senator Hedelman.
Thank you very much, Mr. Chairman. I had a chance to look at the testimony of the city as well as the Attorney General's office. And it sounds like the crux of their argument is that they would be, the state and or the city would be forced to assume the indemnity and the defense and the costs associated with it. And I know that this law has been changed in other states. So I'm wondering how public entities in those other states have handled their concerns.
Once again, I'm going to lateral that question to JB. So if you would unmute him, let him step up to the plate.
Happy to respond to that one as well, Senator Hedelman. I believe that there hasn't been any significant impact in any of the states that have implemented or enacted similar legislation to prohibit the upfront duty to defend. What we've gathered from most of the opposition is it's a question of, well, why can't we transfer that risk to the architect or to the engineer by virtue of the contract, and limiting our ability as the state or as the procurement agency to transfer that risk limits our ability to recover in the event that the design professional is at fault. And like I said, the bill itself we did our best to make clear that nothing prohibits indemnification where the design professional is at fault. To the extent the design professional is at fault, we can't really understand, we struggle to understand why those in opposition to the bill would want to hold the design professional responsible for claims which they were not legally liable for in the first place. And so as a matter of public policy, we think that it's one thing to require your insurance, and you pay for insurance in order to transfer some of the risk or mitigate some of the risk that at some point you might get sued as a property owner, for example. You buy premises liability, general liability insurance for that. Why you would want to hold everybody who ever worked on your property responsible for claims that arise on the property, it seems like we should be focused as a matter of business fairness, hold the parties responsible who caused the loss. And nothing prohibits any of these entities, the city, the state, or any procurement agency, from recovering full fare for any damages that are established to be caused by the design professional, in addition to any defense costs that were incurred in connection with defending those claims. So we think the proper avenue would be tender the claim. If you're a private business owner and you have insurance, tender the claim to your insurance provider, get counsel. We'll also probably be there with you, sued along with the other parties. We'll defend our own design, and we'll let the courts figure out responsibility. And once responsibility is established, then everybody will work together to pay those claims. We think that's the fair way to do it, rather than just tendering claim before fault is established.
So I understand that, but do you agree with their assessment that that enacting this legislation shifts the risk from you to them?
No, I think that they have that risk in the first place as the premises owner. So think about it. If you are a homeowner and you hire a contractor to come in and work on your home, you still bear the risk as the homeowner that somebody walking up your driveway may slip on ice. But to transfer the risk to your architect who designed your driveway, that anytime somebody slips on your driveway, your architect should have to defend you against that claim, whether or not they're at fault. It just seems a little bit nonsensical. The owner, the contracting party, still has that risk to begin with. It doesn't transfer or impose risk from the engineer or the architect onto the owner. It just prevents them from transferring that risk to us before liability has been established.
Thank you.
Excellent. Thank you very much, Senator Hellman. All right, looking to the committee for additional questions. Seeing none, that will conclude the hearing for Senate Bill 161. Thank you, Senator West. We'll now move on to Senator Lee with Senate Bill 41. Senator Lee, the floor is yours.
Yeah, thank you, Mr. Chairman. You might remember this bill from last year. It was SB 57. This bill, in its form, passed with two provisions, both this body, but also the House body. But on the last day of session, it didn't complete the passage process. So this is before you again. You may recall the two provisions. I was a member of the work group to study child custody proceedings involving child abuse and domestic violence allegation. And this is a result of that work group, if you recall the previous bill. One provision has universal support to require judges to articulate the reasoning of their findings when there has been a finding of abuse, which is basically a no-brainer. Many families deserve to know whether they prevailed in a custody hearing or they do not, why the judge made that determination, especially if there were to trigger to not Section 9/101 that prioritizes protecting the safety of children, other best interests of the child factors. That is law and should remain law, but clarification of requiring articulation of the reasoning is paramount to ensuring that families get justice and children are indeed protected under the law. Excuse me. I got a frog in my throat. The second provision might indeed need some work, and we are open to suggestions from the AOC. practitioners and the Office of the Public Defender. We hope to hammer out those concerns because pro se litigants especially should know what that law means by unjustified and whether we should spell out protecting a child from the real physical harms, especially trumps the court order made without the knowledge that protective parent has in that moment. If people are already violating what unjustified means, then doesn't that highlight the need for more clarity? It appears that the administrative office of the courts, AOC, may agree to a degree because they have offered their own language to help with that interpretation. And judges do need guidance just like anyone else. Perhaps, especially if they are concerned about going to be blamed for their mistakes. In child custody, the precautionary principle might make more sense than a rigid enforcement of court orders or the perception that they will go to jail if you try to protect your child from abuse. Ironically, you could go to jail or subject yourself to the CINTA proceedings if you fail to protect your child. So it's kind of like a catch-22. So for these reasons, we've asked a favorable vote on SB 41, which is cross-filed with Delegate Atterbury's bill, who was the primary sponsor last year.
Excellent. Thank you very
Any
much.
questions? Oh, excuse me, Mr. Chairman. Are there any questions?
No worries. Thank you, Senator Lee. We'll take questions at the end of the panel. Thank you.
Okay, sounds good to me. Go ahead.
Excellent. So we'll now switch over to your proponents, and we will start off with Ms. Villamar from the Office of Public Defender. So you are up next. Welcome. Oh, one more time. There you go.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chair, and members of the committee. My name is Nina Villamar, and I am the Chief Attorney of the Parental Defense Division of the Office of the Public Defender. We represent parents whose children have been separated from them by the government, specifically the Department of Social Services. We urge this committee to return a favorable report on this bill, but with 2 amendments. Let me first say at the outset that we are not opposed to safeguards in place to ensure that children are not returned to a dangerous situation. But our position really is to the application of the family law statute being applied to a child in need of assistance case. We call that a SINA case that is governed by the juvenile statute. The SINA statute is a very comprehensive one that was written keeping in mind that the biggest and most important difference between a custody case that happens in family court and a SINA case that takes place in juvenile court is that there is a different burden of proof depending on who the opponents are in the case. Family court is where 2 parents fight over custody of the child, but juvenile court is where the state is fighting to keep the child away from the parents. So we agree that this sort of protection is needed for the children, but we disagree on who has the burden of proof. No further likelihood of abuse or neglect. In a SINA case, the burden should always be on the government. It should never be on a parent to prove a negative. And that is because of the constitutional protections that belong to parents in a SINA case. That's why parents in a SINA case have the right to counsel. That's why they have a lot of extra due process protections that private litigants don't have in a family law case. So the first amendment that we're recommending is to either exclude the application of these provisions to SINA cases or to include language that says that when it's the Department of Social Services who's opposing custody, the burden of proof is on the Department of Social Services. And committee members, the other amendment that we are suggesting is included in my written testimony. So I will leave it at that, and I am open for questions when the time is right. Thank you.
Excellent. Thank you very much. And we'll now move on to Ms. Ruth. You're up.
Good afternoon, Mr. Chair,
Mr. Vice Chair, members of the committee. My name is Lori Ruth. I'm the legal director at the Women's Law Center of Maryland. Once again, as I did on my prior bill, just to point out that the Family Law Section Council of the MSBA also put in written testimony, and Ms. Pop has that testimony. We are favorable with amendments on this bill, a little bit different, I think, perspective than Ms. Villamar, who I respect very much. And in the interest of time, I'll just skip to the part that we think is problematic. So it's really the proposed changes to section 9-105. We have several problems. The first is we think the language, which is at the bottom of page 2, is redundant to language on lines 21 and 22 of that same page and doesn't really move the ball in any way. Second, the language itself in that proposed amendment is very circular. So it's saying that if the acts of a parent are reasonable, they can't be unjustified. But the problem with it is that it suggests that it's litigants who get to make that decision. And I think it's a false premise to put before people who might read this statute or parents, because, you know, most parents think they are the ones acting reasonably. And so, you know, just to give you one hypothetical that we've seen a lot in the past 2 years, we may have one parent who does not believe in vaccinations for their child and another parent who does believe in vaccinations for their child. They both think they're acting reasonably. Under the current bill, under 9105, if they say I was acting reasonably and not sending the child to the other parent, this seems to suggest that they decide that, and then it by definition can't be unjustifiable. But it's not litigants who make this decision, it's courts, it's judges. And so I did speak with several very active family law practitioners. I did not tell them anything. I said, tell me what you think when you read this language. And they said exactly that. They didn't know each other, they didn't know me and what I was saying about the bill. They said, this is really potentially very dangerous language in 9105 to give parents the impression that they're the ones who are going to be the final arbiters of reasonableness of their behavior. It just sort of belies how the court system works. Courts always are looking at the facts and they're assessing the reasonableness of a parent's behavior when they're making decisions, hopefully in the best interest of the child. So that's the part that we have the biggest problem with, and we would suggest that it be struck. And again, I am in support of the 9101 language. And for those reasons, we would ask for a favorable report with amendments. Thank you.
Thank you, Ms. Ruth. Next on the list, we have Ms. Kenny, who I know testified on an earlier bill. Is Ms. Kenny with us? All right, I don't see Ms. Kenny. So that concludes those who are favorable or favorable with amendments. Questions for the sponsor or for the panel? All right, seeing no questions, we'll move on for those who are testifying in an unfavorable position. Mr. Eichenbaum, you are next.
Can you hear me? Hello? Yep. Okay, thank you very much, Mr. Vice Chair. I think that Ms. Ruth took the words out of my mouth and said it much more eloquently than I could. My concern is exactly what she talked out, that we're basically putting the law into the hands of whatever a parent wants, which is a very dangerous precedent. Just wanted to add two more things onto that. The origin of this law, from my understanding, is really in part to combat parental alienation claims. And I'm not making up myself. This is in a 2010 paper from Joan Mayer, where she talks this out as a mechanism to try to preempt any parental alienation claims. So obviously, it's not only relevant to parental alienation, but it can be used as a weapon, that any parent can just say that, oh, I'm afraid for the safety of my child, just to withhold the child from the parent. So that is a concern also for me, just the origin of it and how this could be misused in legitimate parental alienation cases against innocent parents. So those are my basic concerns over here. So if those concerns could be alleviated and done in a way that would protect targeted parents from being alienated and also to balance it so it's not just a Wild West, then I wouldn't have any problems with the bill. But until that happens, I'm very uncomfortable with it. Thank you for listening.
Thank you for your testimony. Next, we'll go to Mr. McAvoy.
Thank you so much, committee. I hope that you can hear me all right. Thank you. This bill has, as we just mentioned earlier this afternoon, the DNA of the SB 567 work group. When you look at the legal construct, and I'm a little confused that my former colleague at SINA referred to this as in that purview. This would apply to all child custody cases. This is Family Article 9. This would give a parent the ability to say, I'm concerned about safety, that trumps everything. Now, again, this is what we mean when we say that these things are set up and biased, that we have an issue where unprovables are offered, the child is withheld. This is gatekeeping, this is parental alienation. And then subsequently, you go to court, and you know what happens in Maryland if you have made an allegation? Nothing. No makeup time, no charges, no fees, not even we're sorry, we got it wrong. That's the way we have things set up. It shouldn't be that way. I've been telling them for a long time, it shouldn't be this way, okay? But we have no skin in the game from these false allegations when they come up. The bill should be struck in its entirety. The premise about the safety of a child, it doesn't even concur with CDC stats, which were mentioned earlier. Over 56% of child abuse happens in the custodial home. In Maryland, 6 out of 7 custodial cases go to the mom, not the dad. Okay. So when we look at bills like this, what is it really offering? Nothing. This is almost, it looks like a vendetta bill. I want to just briefly close talking about neglect. Neglect can be just about anything from the court standpoint. And it's almost always unprovable. Yes, that doesn't mean all abuse is unprovable.
Time.
And you know me to be a firm advocate where we have solid evidence of prosecuting it. I ask for an unfavorable for these and all that share this DNA. Thank you for your time.
Thank you, Mr. McAvoy. Questions from the committee for the opposition? All right, seeing no questions, that concludes the hearing on Senate Bill 41. We'll now move on to the final bill of today, Senate Bill 30. Senator Carter, you are up.
Yay, we finally gotten here. Good afternoon, committee and Mr. Vice Chair. This is a bill that we have successfully passed in the previous year, and given its merits, I hope that we will easily pass it again this year. This is a bill that basically ensures the reenfranchisement of Marylanders who have been disenfranchised by outdated laws adopted in days of old. In the late 1960s, in the shadow of the 1965 Voting Rights Act, Maryland, as well as a number of other states throughout the South, passed a plethora of laws that snatched away basic rights of citizenship from those who found themselves incarcerated, many of whom tended to be Black males. Among those rights taken were the right to vote and the right to serve on a jury. Given this legacy, 1/3 of Black males in Maryland are ineligible to serve on a jury, diluting the jury pool of peers of African-American defendants. In 2016, the Maryland legislature led the way by being one of the first states in the country to reenfranchise those who had completed their felony sentences and granted them the right to vote. As a consequence, Maryland achieved full voter enfranchisement that year. Senate Bill 30 takes the next step of restoring important liberties available to other citizens, the right to sit on a jury and have criminal charges tried in front of a jury of your peers. We can be proud of our leadership in emancipation, but we have more work to do. I ask that we step up to the plate and re-enfranchise those who currently cannot serve on a jury and restore this important right of citizenship. Doing so will place Maryland on track with 20 other states and the District of Columbia by allowing formerly incarcerated individuals to serve on juries. I also want to point out that last year we did put an amendment on the bill that addressed those with pending charges. This bill is drafted with that amendment as we passed it, which basically does disallow those to serve on juries if they are pending their charges and they have not yet been adjudicated. Because of our new time restraints for presenting or signing up for our witnesses, I did have an important witness that was unable to sign up in time, and I'm not going to read his testimony, but I do want to mention Mr. Walter Pinkney, who had a felony conviction in 1999. As of the year 2017, he's finished everything serving his probation. And he says, when I got out, I learned I was eligible to vote in elections, but also learned that I am not allowed to serve on a jury because of my felony conviction. I think serving on a jury is one of the rights that all Americans can be proud of. When you are on a jury, you play an important role at determining whether or not a person is guilty of a crime. This is something I look forward to doing if Senator Carter's bill becomes law. I understand that her bill will allow a former felon to serve on a jury as long as they have completed their sentence and finished their probation and don't have any charges pending against them. I think that will be a fair law. I think that if I were on a jury, I would listen to all the facts and make a fair judgment about innocence or guilt. And I don't think I would be partial to the person charged. I would be fair and I would look at the facts that I heard in court. Like I said, I have totally turned my life around. I currently work for a roofing company in Baltimore. I have a wife, 2 children, and a grandchild. I've learned my lessons and served my time. I hope to be able to take advantage of the right to serve on juries in the future. And that's from Walter Pinkney. And next, I'm happy that you'll hear from John Giannetti and former Judge Jarachow, if I'm saying that right. Jarachow.
Thank you, Senator. Let's go to Mr. Giannetti. Senator Giannetti, please.
Hey, terrific. Thank you very much. I appreciate the opportunity. Mr. Chairman, actually, Mr. Vice Chairman, members of JPR, I am John Giannetti for the MCDAA. It's been 16 years since I had the opportunity to sit on that committee. I admire what you're doing. You've had a long hearing today. I'm not going to make it much longer. I admire what you do. I wish I was down there with you. Actually, I'm not too far from you. I'm in Annapolis. I'm only about a mile the way the Raven flies from you right now. I'm happy to see Mr. Watson, Senator Watson. Good to see you on that committee. You're the newest member as the self-designated alumni chairman of the JPR. Welcome on board the committee. It's a great committee to have you on board. So I'm testifying in favor of SB 30 for the Maryland Criminal Defense Attorneys Association. This bill is exactly the same way you passed it out of committee last year. We added an amendment, or Senator Carter added an amendment. The House version has the amendment also. It's how it passed out. When it passed out of committee, it got a Republican vote in the committee. And when it got to the Senate floor near the end of session, it got 4 Republican votes. I think it was Senator Hershey, Senator Edwards, Senator J.B. Jennings, and also Senator West, who voted in committee. So it had some good bipartisan support. I think that's it made it a stronger bill. I hope that the House is able to get some Republican votes on it too, but it passed the House, it passed the Senate, and now that it's stronger, I hope that it can pass both houses the same way. The amendment is exactly the same as it passed it out of the House, and what it does is it does this. It says if you have current charges pending, then you're not eligible to serve on a jury. And then listen, that gets rid of all the questions that we had that was on the floor of the House and in the Senate about voir dire. And it's a complicated issue. It minimizes that issue and says, listen, if you have pending charges, even if they're misdemeanor charges like an assault charge, you're not eligible to serve on a jury. It takes that issue out. But what it does do is it widens the jury pool, and that's the effort here. I sent you guys in a support document. You guys saw it. Okay, it was but what's important is what was attached to that, and it's a really good document. This was published after the hearing last year, and what this did was this actually gave everybody. This gives you a map of the entire United States, and if you look at that, Maryland is listed in blue with only a few other states like Texas and Oregon. We're the most restrictive for people in as far as serving on juries. We should not be in that place. We should be understanding and re-enfranchising people. That's what this bill does. And I want to make one quick little statement about this. Had the hearing last week in the House.
Conclude, Mr. Senator, go ahead.
Okay, thank you very much. I just want to say that we put out an APB to the MCDAA, and we had at least 10 people that could come and testify who are directly affected by this bill. We didn't bring them in, and but I will have you know there are plenty of people who this affects that would love to serve on juries. Thank you very much, members of the committee. I appreciate your time.
Thank you, Senator. Mr. Jericho, you are up next. Go ahead, Judge.
Thank you, Senators. My name is Ronald Jericho. I'm testifying on behalf of the Maryland Association for Justice. We've also submitted written comments, which you should have. I am a former judge on the Circuit Court for Anne Arundel County. I returned to law practice in 2011. This bill is really to create fundamental fairness in trial. It's both civil trials and criminal trials. The current law of Maryland says if you've had a sentence, whether it's for misdemeanor or a felony, for over 1 year, you are excluded for life from serving on a jury. So this bill will justify permitting people to get back into the system and be able to serve on a jury if they've paid their debt to society, if they are not currently in jail or under probation. And there is a this is all consistent with the Duran case, which I cited in the paper from 1979. The Supreme Court said that a jury is supposed to be composed of members of the community. And the Maryland Court of Appeals adopted that same rule in 1997, saying that's necessary for a fair and fundamental trial, whether it's in primarily those cases are in a criminal context, but it's criminal and civil. And so if you look at my paper, I've also cited a study from 2003 that confirms what the sponsor has said, that over 30% of Black men are excluded from serving on juries because they have had sentences that are excluded under many laws. So this bill will balance the ledger, allow people who have served their debt to society to get back and serve on juries and restore their rights. With that, we request a favorable report from the committee.
Thank you, Judge. Next, we'll go to John Breen. Mr. Breen.
Can you hear me, sir?
I can. We'd
Okay.
welcome you to turn on your video if you can, Mr. Breen.
Thank you, sir. Do you have my video?
We do. Go ahead, Mr. Breen.
Okay. I'm Attorney Jack Breen, Annapolis, Maryland. I'm supporting the position of MAJ and the law that Ron Jericho has spoken to you. I won't repeat that. I just refer again to Lovell versus State, the Maryland American Appellate Court decision, which wants to have a fair trial. So remember, a standing trial can have representatives of the entire community on that jury deciding this case. I want to add one additional perspective. For 4 years before I studied law, I was a parole officer in a maximum security prison. I know this population well. And I would talk to people in church basements on Sunday evenings, looking for someone in the legitimate community to sponsor these people as being a contact person to resolve their day-by-day or week by week issues. It's a tremendous incentive for people who have done their time and may be remorseful after they've completed their time. And here we're all talking about parole or probation, to be welcomed back into the community of those who've chosen to live on the right side of the law. And that incentive is two things. It's a reward. It's the right to be in a voting list, and it's the right to sit in a jury. It's a reward. It's like getting a private Nobel Prize for these people who have spent, in my case, sometimes between 5, 10, or 15 years in a maximum security prison. I can't impress upon you enough. In my view, that's one of the incentives that these people need, former prison inmates, former parolees, to encourage them to continue not going back to the street life they left before that brought them back to prison again. In my view, these kind of recognitions help reduce the rate of recidivism. I won't discuss the rate of recidivism here. I'm just pressing you to support this bill because I believe it helps reduce that and encourages walking on the right side of the law for these people leaving prison or parole. Thank you for your time.
Thank you very much, Mr. Breen. Next is Elizabeth Hilliard from the Maryland Office of the Public Defender. Ms. Hilliard.
Thank you, Senator Hettleman and members of the committee. Elizabeth Hilliard, I'm the Assistant Director of Government Relations for the Maryland Office of the Public Defender. The Maryland Office of the Public Defender strongly urges the committee to issue a favorable report on Senate Bill 30 for two reasons. First, as actually Mr. Breen just very extensively covered, it acts to re-enfranchise and restore persons who have served their time for their convictions back to full members of their community. It allows them to perform the critical civic duty of serving on a jury and being participants in the jury pool. Second, as Mr. Giannetti and Judge Jerichow discussed, we currently exclude a significant portion of the population from our jury pool, rendering us unable to comply with the Supreme Court mandate that, and I'm reading directly from a 1975 case, Taylor versus Louisiana, the court has unambiguously declared that the American concept of the jury trial contemplates a jury drawn from a fair cross-section of the community. In 2010, nearly 19 million Americans had felony convictions. An estimated 36%, nearly 7 million of those 19 million were Black, despite the fact that Black people comprise only 13% of the US population. In order to properly restore our jury pools to a fair cross-section of the community, we need a bill like Senate Bill 30 on the books. Thank you.
Thank you, Ms. Hilliard. Next, and rounding out the favorable side of the panel is Kimberly Haven from Forward Justice Maryland. Ms. Haven.
Good afternoon, members of the committee. It is so good to be back in front of you again. I've missed all of you. My name is Kimberly Haven. I'm here on behalf of Forward Justice Maryland, but I'm also going to talk a little bit from a more personal and to something that Mr. Giannetti referenced. I'm here today in support of Senate Bill 30. This is both a clean, no fiscally note impacted. There's support for this. This is just good policy. I've now been home from prison for many years. I am the executive director of 3 organizations, and I'm the policy director for 2. So my name is on the rolls. And each year I get my jury summons and I dutifully fill it out, and then I get to the conviction question. As recently as 2 months ago, I got another summons. I had to submit, along with my questionnaire, copies of all of my criminal charges at my expense, only to get a thanks, but no thanks letter. You would think by now that they would remove me from the rolls, but no, they have not. So I will get another one next year, I assume. Jury duty is a civic responsibility. I hear time and time again that somehow because someone has been incarcerated, they are going to find everyone not guilty, that we are not concerned with public safety. To believe this is to believe a false narrative. As a citizen, as a voter, I should be able to report for jury duty like my peers and answer truthfully any conviction questions put before me. I can be dismissed by the prosecution and I can be dismissed by the defense, just like my peers. To deny me the opportunity to do my civic duty, to preemptively bar me from doing my civic duty just because of a criminal record only contributes to the continuation of the over 1,100 collateral consequences and the stratification and stigmatization of individuals in our community. We should be able to do our duty and, like our peers, be dismissed but not denied. I urge a favorable report on SB 30. Thank you very much.
Thank you very much, Ms. Haven. I guess we could do questions now for this side of the panel. Anybody have any questions? All right, we'll move on to the unfavorable, and we have Joseph Riley, Maryland States Attorneys Association. Mr. Riley?
Thank you, Senator Hellman. My name is Joe Riley. I'm the elected state's attorney for Caroline County, the legislative chair for the Maryland States Attorneys Association, and we are seeking an unfavorable report on Senate Bill 30. This bill is characterized as a civic reenfranchisement bill, but is in reality a boon to the criminal defense bar. I will commend the panel for actually finding someone who this law would quote unquote benefit to speak that they would want this because every time except for today we have had only members of the defense bar like the Office of the Public Defender talking about how this bill would benefit society, but actually not having anyone who would speak on these bills. Typically in civic reenfranchisement bills, we hear people talking about compelling stories about getting a license, perhaps to be a barber, perhaps to be an accountant, and how this would change their lives. Typically, we don't hear those in this types of hearing. I heard a lot of discussion about fair trials. The reality is in criminal trials, in a felony case, criminal defendants get 10 strikes, the state gets 5. On life without parole cases, the criminal defendant gets 20, the state gets 10. So the state is already at a disadvantage when it comes to jury selection. This will make a greater disadvantage. Yes, the state does have strikes, but we do not have the same number of strikes as the defense. I will also note that the talk about this being unconstitutional, there's quotes from the Supreme Court, from Supreme Court cases from the 1970s. I think we've had 1 or 2 jury trials since 1970, since 1975, and our jury verdicts have not been overturned. So the fact that they're quoting Supreme Court cases does not mean that there's Supreme Court precedent for this law. We seek an unfavorable report, and I will answer any questions that the panel has.
Thank you very much, Mr. Riley. So are there any questions from the members? I don't see any. All right. I think if I am correct, that concludes the afternoon.
You are correct.
Great. Thank you, everybody.